Yes.
11 and 63, Lordship.
11. Yes.
Till he is out of station, Lordship. So matter may be adjourned for the day.
On the prayer of MS. Yes,
I'm
that's
appearing on behalf of Mr. A.Y. Chaudhary, Lordship.
the council appearing on behalf of Mr. A.Y. Chaudhary, the council for the petition. Let this matter be listed after 2 weeks.
Week, Lordship.
Huh?
After a week, Lordship.
After a week.
Lordship, on item number 63.
63.
63, Lordship.
Same.
Same prayer, Lordship.
After a week. What is 63?
Of supplementary list.
2 weeks. Here 2 weeks. You are here, F.U. Burbuya. Appearing on behalf of F.U. Burbuya. Item 63. After 2 weeks.
Also, I'm praying for listing of 2 motion matters on Wednesday or option.
Please, Lordship, I beg to mention item number 32 to 36 also. with consent
32
of-
to?
36 with consent of the petitioner, Lordship. For 2 weeks, Lordship.
Why?
Lordship,
is
on
for
previous
what?
occasion, Lordship, they sought some
Oh,
time to
fine,
file an
it will be
affidavit, Lordship.
Huh?
With Lordship.
Okay. No objection.
We don't have any objection, but Lordship, a date may be fixed because on previous occasion as well, they sought time, Lordship.
What is the matter about?
Lordship is regarding senior grade pay promotion, Your Lordship. Senior grade pay promotion, Your Lordship.
Okay. On the prayer of Mr.
Yeah.
S. Buya, the Standing Council, Higher Education, and the prayer not being objected to by Mr.
P. Khatonian.
P. Kathania, learn counsel for the petitioner. Let these matters be listed after 2 weeks. To file for filing so as to enable the understanding council to file affidavit in opposition.
Lordship, may I pray for a date, Your Lordship?
After 2 weeks,
6th, maybe? 10th.
10th may not be. After that.
9 to election.
After 10th,
After-
Bihu.
After review vacation.
That is it.
Yes,
May I pray for an adjournment in item number 15, Lordship, with the consent of
15.
the other side, Lordship.
huh.
I'm appearing on, making a mention on behalf of Mr. S. Chaudhary. He is not keeping well, Lordship.
On the prayer, Mr. So-and-so appearing on me, Mr. S. Chaudhary, learn counsel for the president. Let this matter be listed after 2 weeks.
Lordship,
It's 2019 matter. What is the matter?
Lordship, termination from service, Lordship. Lordship. Obliged, Lordship.
May I plead, Your Lordship? I beg to mention item number 37.
Hmm.
Lordship, my senior will not appear today for some personal difficulties. Kindly adjourn the matter for that.
Huh?
My senior will not appear today.
Why?
For personal difficulties. Kindly adjourn the matter for that.
Your senior will not appear today. Huh? Who is your senior?
S. Bhattapur.
Okay. Mr. So-and-so,
A. Nayak. Mr. A. Nayak.
learned counsel appearing on me, Mr. S. Borthakur, learned counsel by petitioner, submits that. His senior, Mr. Borthakur, has some personal difficulty today. Therefore, press for listing of the matter after 3 weeks. List after 3 weeks.
Obliged.
May it please your lordship, I beg to mention for listing of a WBC matter on 26th. Lordship, on that day, similar matters are listed for.
May it please your Lordship. Lordship, with the due consent of the other side, I beg to mention item number 44 of today's my lord, daily list, my lord. My lord, this matter, we are awaiting instructions, my lord. My lord, we'll fix it on
On the
Friday.
prayer of Mr. Fukan, A. Fukan, learned standing as elementary education. Further 3 weeks time is granted to file.
We have some urgency, your lordship.
2 weeks time is granted to file affidavit.
We'll get it.
Mr. So-and-so, so-and-so. Your name, please.
BJ Mukherjee.
PJ Mukherjee. PJ Mukherjee, learned counsel is present.
Please, Your Lordship. Your Lordship, I'd like to mention item number 22 and 57.
20,
22,
22 to
22 and 57.
27. Why?
Taking adjournment for today.
Okay. On the prayer of so-and-so,
H. Pame and
appearing on behalf of
A. Chakrabarti.
A. Chakrabarti.
And
Let
Your
this
Lordship,
matter be listed after 3 weeks. And item
57.
57.
Lordship, item number 22, there's an interim order to be conveyed.
Interim order parcellation. 57 is for what?
57 order,
Ah,
there is for stoppage of.
okay, same. H. Chakrabarti, yeah.
May I,
Right.
may I please, your lordship, I beg to mention item number 6 for motion.
Mm.
This matter may kindly be adjourned for a day, lordship.
Why?
I'm appearing on behalf of JU and Lashkar.
Ah,
He has some personal difficulties, lordship.
on the prayer MS?
My name, KLR Yanthan.
Ah. Appearing on behalf of Mr. JUNM Laskar. Come on, let this matter be listed after 2 weeks.
Lordship, any date.
2 weeks.
May please, your lordship, item number 17,
Hmm.
my lord, may be taken.
70.
17,
Ha. Yes.
after 2 weeks, my lord.
17. If Jed Hussain.
My lord,
Hawk.
Jat Hussain,
Jed Hussain. On the
Right.
prayer, Mr. So-and-so.
after 2 weeks, my lord.
Let this matter be listed after 3 weeks.
Obliged.
Mr.
NZ Chaudhary.
NZ Chaudhary, Land Counsel for the petition submits that. And then submits, he has an instruction to withdraw this writ petition. Please step. MS
For SSA, A. Borthakur appearing on behalf of Mr. P. Nayak.
is present, huh? Correspondent is present. Accordingly, writ petition stands close on withdrawal. Huh?
Lordship may
Aye,
provide
sir.
liberty if necessary arises.
Huh?
Lordship may provide us liberty.
What
to
liberty?
something cause of action arises, first cause of action. So
Then in that case, as an instruction, withdraw is with the liberty to file afresh. Huh? MS so-and-so is present accordingly with liberty.
much of Lordship.
This is contempt against the Malad
Where is the order?
order, Lordship, at operating part at page 31, Malad.
Ah,
The Education Tribunal, Malad, passed an order directing the author, respondent number 2 and 3 to appoint the Malad petitioner. But till date, they have not implemented.
Education Tribunal.
Yes, Malad.
So why we should have this?
Malad, contempt jurisdiction is before this honorable court, Malad. Earlier, he approached the honorable court, then directed the petitioner to approach the educational tribunal. And educational tribunal disposed of the case, directing the respondent to reinstate him and to provincialize his service. So, the respondent is yet to implement the order. We have submitted the copy of the order along with a representation. They are not considering it.
Who has to?
The director and director,
Which order you are, alleged to have been violated?
it starts from page 15, Malad.
Huh? By whom? This order of whom?
By education tribunal, Malad.
Wow.
Borpeta.
So why would you should
Section 10 contempt Court Act, Malad.
no. It's a you file an execution. It's a tribunal passed by the tribunal.
Yes.
File an execution.
Malad, this is an order, judicial order, Malad. That is
So
why.
what? It's a by the tribunal. There must be some procedure to implement the order.
Section,
It's not a contempt.
Malad, section 10 of the Malad, Contempt Court Act, Malad.
Think about it. It's not that. See, contempt of court act. It's it by the tribunal.
Yes.
There's a process. It's not a criminal proceedings.
No, no. Section 10, my lord. High Court rules also, my lord.
No. It's by the tribunal. Think over it.
Lordship will fix their,
Heard
no
Mr.
Wednesday, my lord.
NK. Kolita, learned counsel for the petitioner. By filing this, this application, the petitioners. No, this application is instituted as in alleging violation of order passed by the presiding officer, Education Tribunal, Barpeta. This stuff, under section, seeking invoking of section 10 of the Contempt of Court Act 1971. This stuff. Considering that the order alleged to have been violated is passed by the election tribunal, education tribunal.
Education.
Let this matter be listed after 2 weeks so as to enable the learned counsel to
All right.
obtain necessary instruction. No, to consider whether the petition would lie before the court, whether the application in the present form would lie before the High Court. Think about it. It's not all this thing. There's so many judgments.
Okay, my lord.
Otherwise,
I'll go through it.
Otherwise, you could have dismissed today.
The order is at page 64, okay? It starts with paragraph 14.
Page
Page 64.
uh,
Having considered the above judgment and order, that's it. And also.
64.
Page 64.
Yes.
Having considered the above judgment and order and also considering that the petitioners are the regular Hindi teachers amongst the 82 Hindi teachers, I am of the view that the present petitions are entitled to be granted the similar relief as provided in the above judgment and order and under consequential orders of the respondent authorities by the order dated 10/10/2022 by granting enhanced scale of pay with retrospective.
2 months. 2 months.
Yes, sir.
2 months.
Yes. 2 months. Yes.
When it was, when you filed the certificate copy?
What's it? I submitted what with on.
Okay. Heard, Mr.
That's good, that's good.
Learned counsel for the petitioner. This is an application under section 11 and 12 of Contempt of Courts Act 1970. Read with Article 215 of the Constitution of India and the Contempt of Courts within bracket Gauhati High Court bracket clause rules 1970, alleging willful and deliberate violation of the order dated 02/04/2025 passed in WPC 4400 of 2025. This stuff. Next para, issue notice returnable by 4 weeks. Learned counsel for the petitioners to take steps for service of notice upon respondent number, palace contempt number 1, 2, and 3 by speed port as well as usual course during within 3 working days. Yes.
Item 3. Lordship, it would be 4400 of 2024.
Huh? What I said?
25.
Huh?
44 WBC 4400 of 24.
2024.
Obliged.
4400 of 2024. Yes.
Obliged.
Yes.
Page 11, my lord.
Ah. 2 weeks
Yes.
from the date of receipt of certificate copy. When is the order passed?
Order, my lord.
28.
Yes.
Yes. 2 weeks. When did you submit?
They submitted, my lord, on by
They have received it.
I received it on 30/12/2025 my lord, by post submitted.
When they have received it?
Yes, by speed post it is submitted. Within 2-3 days.
Okay, this is an heard Mr. B. Purkasta,
Yes, sir.
learned counsel for the petitioner. Same violation of alleging willful disobedience and violation of the order dated 20/08/2025 passed in WPC 4714 of 2025. Issue notice so and so, same.
Yes.
How many respondents?
Four, my lord.
4, 1, 2, 3, and 4. Let's check it and do it.
Item 4. Made to the law.
Yes.
This is for non-compliance of an order which is at page number 33.
Huh?
Non-compliance of an order dated 17/3/2025. Passed in
Same.
WPC 3597 of 21. The 11th page lordship will get at
Not
7.
MHLS learned counsel for the petitioner. Application under so and so, alleging willful and disobedience and violation of judgment ordered at 17/03/2025, passed in WPC 3597 of 2021. Issue notice so and so. How many respondents?
2 response.
1 and 2. 4 weeks, all 4 weeks.
Item 5. Made.
Yes.
Matter pertaining to my lord suspension, my lord.
Ah.
Last occasion instruction was sought for my lord
Ah.
on 9/2/2026. my lord.
Here instruction is awaited, my lord, so sometime may be granted to us, my lord. Instruction is awaited, my lord, so sometime may be granted to us.
Next week.
Yes, next week.
Heard Mr. M.
M.
Kalita,
Kalita.
learned counsel for the petitioner.
You, Sharma.
Mr. U. Sharma, learned counsel for the petitioner.
Secondary
Learned standing counsel. What is this?
For-
Secondary
Yes, my lord, for respondent number 1.
learned standing counsel. Secondary education.
Yes.
Press for further 2 weeks time.
1 week.
Further
Yeah.
a week's time to obtain instructions as directed by this court on 09/02/2020.
My lord,
Yes,
kindly
after
state
the
that.
week.
After view vacation.
Friday, make it Friday.
Friday.
Friday, after 1 week, Friday.
Yes.
Item 7.
Map results.
Yes.
My lord, pursuant to an advertisement, page 100, annexure 8, my lord, of the writ petition for regularization of the teachers who
Ah.
are working on contractual basis of state school, my lord. The petitioner qualified all the requirements mentioned, conditions of recruitment mentioned in the advertisement and duly applied, my lord. Thereafter, my lord, selection was conducted from amongst the, my lord, state school teachers, all of them were selected. The case of the petitioner was never considered, was due to the fact that, my lord, he was not informed anything written, but on query, my lord, they have informed that his name was not appeared in the dias code of UDIAS of 2017-18, 17-18. But fact remains that, my lord,
There's no order as such.
lordship,
There's no order as
there
such.
is not.
Yeah.
For that, this
Heard Mr.
JMA Chaudhary.
J.M.A. Chaudhary, learned counsel for the petitioner. By filing this application. No, agreed by non-selection.
In merit list, my lord, dated
No, challenge made in this writ petition is today. Provision merit list
Yes, my lord.
dated 06/02/2026. What it is?
Page, my lord, 105.
Published by whom?
My lord, Director of Elementary Education.
Page.
Page 105, my lord.
Published by the
Last page 162. Director Elementary Education, Assam, Kailipara, Guwahati 90.
162.
Yes, my lord, last page.
Published by Director Elementary Education, Assam. For the post, for
Regularization of state.
no, for appointment to the post of teachers of lower primary schools
Yes,
pursuant to the advertisement
Page
dated
100.
28/10/2025 as the petitioner and then as the name of the petitioner is not found place in the said list. Huh? Then what is your thing?
Lordship.
What is your case?
Case is that, my lord, though petitioner submitted his representation on page 102.
What representation? How you have not been selected? Why you are claiming that you should have been selected?
All of the similarly situated persons who are.
What similarly situated? See, selection, of course, everyone will be similar. So selection means what? You get the best.
Yes, my lord, I was not informed about the non-selection in the merit list. But upon query, my lord, the authority informed that my name was
It
not.
is the case of the petitioner that similarly situated persons have been selected. However, the case, the petitioner has been selected on the ground that the name of the petitioner, what here?
UDICE.
Doesn't appear.
In the UDICE of 2017.
UDISE of
17.
2017 to 2018.
Though his name appeared in 1617 and 1819.
It is contended that the name of the petitioner appeared pre and post 2000, I mean, prior to and post 2017 and 2018, which could not have been, for which the petitioner could not have been which the petitioner could not have been for which the petitioner could have been selected as the petitioner is eligible in all respects. List of issue notice returnable by foreigns appearing for all.
1, 2, 4 and 5.
Mr. P.N. Das. P.N. Sharma, Learning Standing Council.
Elementary. For
For
respondent number 1, 2, 4 and 5.
On behalf of respondent 1,
1, 2, 4 and 5.
1, 2, 4 and 5. And who else?
My lord, my lord, SSA. Someone is appearing.
No format notice need be served in respect of above
6 lot.
respondents.
6, I have to take my lord steps, my lord.
Our extra copies be furnished to the Land Standing Council. Land Council, but the petitioner next para to take steps for submission of notice upon rest of the respondents.
Only respondent number 6, my lord.
Register by speed post as well as the usual process within 3 working days.
Oblige.
Issue notice returnable 4 weeks, right? 4 weeks. What is this?
His lordship, the petitioner is assistant professor. He was included in the admission committee, but during this, he has the sought for leave, my lord. Then this leave is not granted, but by that time he's left for Delhi, 2 days on absent.
What is
But
the impugn order?
my lord, impugn order, my lord, page 50, my lord. Reply is page 50, 51. Focus is given, so why you are absent.
You are challenging this 50?
Yes, my lord.
Huh?
And then, my lord, another thing, my lord, in service book, some stigmatic remarks also put up, my lord, page 50.
Where it is the order which you are challenging?
My lord, page 50, my lord.
50 or 53?
53 also, yes, my lord.
Huh?
Both, my lord, both are intimation, my lord. That is the so-cause, my lord, that's not satisfied. Their case is that, my lord, 34 leave, 34 discretion power is there, but whether this negligent or, my lord, that question has to be determined. Then, my lord, in service book, why without complete?
51?
Yes, my lord.
51 and 53?
Yes, my lord.
Heard Mr.
MJ Burya.
M.J. Barwa,
My lord.
learned counsel for the petitioner. Next para. Challenge made in this petition is to the intimation dated 01/08/2024 and the intimation regarding the so-called reply. And the so-called reply dated 01/08/2024 and the decision of the governing body in respect of unauthorized absent. No, you just said dated, intimation dated 01/08/2024 and 05/11/2024. Intimating regarding so-called reply and the decision of the governing body in respect of as regards unauthorized absence of the petitioner. By which the governing body of the Silaputra College in its college has resolved to deduct the salary of the petitioner for unauthorized, deduct an amount from the salary of the petitioner for unauthorized absence period for 28 and 29 June 2024.
Another, my lord.
Next para. Yes, why?
My lord,
What is your contention?
My lord, page 56, without, my lord, completion DP, he has some adverse remark that is amounts to sigma. Page 57, kindly see. Because CL is
57?
Yes, my lord. That is also challenged, my lord. Because without DP, my lord, how can the principal write adverse? That is,
Where it is?
my lord, page 57 is this type copy and service book. It is given 65. He is unauthorizedly absent. That was also written in service book. So it amounts to stigma. So his CL is available and some colleagues has done his duty. So without considering all these things, it's just unauthorized absent. That is
Then you continue as also the recording of the same in the service book. List of next para. It is the contention of the petitioner that such decision would amount to
Stigma.
Amounts to an stigmatic on the career of the petitioner as no proper procedure for such decision has been undertaken in accordance as per the law. That too, when the petitioner has what casual leave?
My lord,
What casual leave?
he has 12 casual leaves, so he can
Whether-
avail 6. So in
whether-
spite of that,
That too, when the petitioner has
6 casual leaves
six
available.
casual leaves remaining.
Hmm.
Six casual leaves to be availed.
Yeah.
List of. Issue notice returnable by 4 weeks. All,
1 and 2.
then rest.
Notice
Who else, sir?
to go.
As
3 and 4.
Mr.
Lordship.
Governing body,
And
principal,
Yes.
Mr. D. Upamani, the Standing Council, Higher Education Department. Enters appearance on behalf of respondent number 1 and 2, no formal notice need be served in respect with two respondents, however, extra copies be furnished to ensure petitioners to take steps for service of notice upon this.
Obliged.
3 and 4 by speed post as well as usual process, within 3 working days.
Item 9. Wait, please, your lordship. The petitioner, he is a grade 4 employee of a my lord school, my lord. Earlier, he opposed this code, my lord. And that order is at page 21. But after that, nothing has happened, my lord. Still, see his service is utilizing by the my lord school authority as well as inspector of schools, my lord. I have annexed at page 24 and 25.
Yeah,
25.
you have already been granted relief.
No, no, my lord. That is not considered, my lord. And
If
my lord,
it is-
there was a direction, my lord. Lordship kindly.
Yes, if there is a direction, if it has not been considered, then
No, but till late, my lord, it is pending, my lord. There
So-
are representation. That
so-
is why I am before your lordship.
that's what I'm saying.
My lord.
If the order is not violated, what is the remedy?
I know that is contempt jurisdiction is there, but my lord, let them obtain instruction whether that,
No.
my lord,
See,
that
we
speaking
cannot
order is
pass
passed. That
one
was
after another, above and above, the same direction.
my lord, actually, my lord, what has happened?
If you have missed the appropriate remedy
My lord, actually, my
within,
lord, what has
within the
happened, my
period,
lord?
can't help it.
My lord, what has happened, my lord? After submission of this order, my lord, they have not passed any speaking order
So,
and kept it pending, my lord. He has not approached this High Court in contempt petition.
yes,
Subsequently, his duty is also utilizing by the authorities. Page
Yes.
24 and 25. Kindly see, my lord.
by
This is
speaker within a period of 2 months.
2 months, my lord.
Then?
That is not done, my lord.
If it's not done, then what is the remedy?
Then after my lord, Bholanath versus State of Jharkhand, my lord, he created a right for regulation, my lord. That is why, my lord, I am coming, my lord. Yeah, my lord, state cannot, my lord, keep the employees, my lord, in a temporary post.
What do you
for
mean by
long.
that? I'm
Bholanath
not on
versus
the, I'm
State
not
of
on the merit. Sir, I'm not on the merit. A direction was given
My
by
lord.
this court
My lord,
to consider your case
my lord,
and dispose of the
my
representation
lord.
within 2 months.
2 months, my
That
lord.
has not been done.
None.
Then what is the remedy?
Contempt remedy was there, but it should be filed within, my lord, one year, my lord. That period is also over, my lord.
Then,
We have 2023 order, my lord.
then,
That is why, my lord, the petitioner
Then-
has again approached this court.
no. Therefore, it's not maintainable.
Then, my lord, let me, my lord, another date, my lord, I will establish.
Law doesn't support those who are not vigilant.
Even, my lord, the respondent, my lord, director, he has not communicated about the fate of the, my lord, representation, my lord.
That's why I'm saying, if it is not done, it was there, there's a specific direction to consider within 2 months.
My lord.
That has not been done, then what is your remedy?
And that is also not considered, my lord, and he is also, my lord,
Have you heard about the Rip Van Winkle?
my lord.
Huh?
My lord.
What is that?
Actually, my lord, another date, my lord. I will,
No, what is
I will apprise your lordship.
Have you
my lord.
heard, if you have heard about Rip Van Winkle? Huh? Have you heard it or not?
Not, my lord.
Huh?
My
Should
lord,
I tell you?
actually, my lord,
Should I tell you? What is, there is a classic story, book written by, the story written by American author.
my lord.
The character, the name of the character is Rip Van Winkle, right?
Right.
He slept for 20 years.
My lord.
And when he woke up, world had changed. He tried to find out his right. In that context, even you have slept for many days, you have not availed your right.
That is true, my lord. But my lord,
If that is true, then you have heard about Kumbhakaran. Huh?
my lord.
Kumbhakaran and
But my lord-
Rip Van Winkle are same.
But that is true. There was an order that was not considered. But still, my lord, kindly come to page 25, my lord. His service is utilizing by them, my lord.
I am not on that. The maintainability of the writ petition. Maintainability of the writ petition. We don't do that. Law will never support.
Then let me, my lord, another date may be given. I will explain. The
Will
maintainability.
dismiss.
My lord. Acknowledgement.
Heard Mr. J.C.
J.C.
Gogoi, learned counsel for the petitioner. This petition is instituted seeking the same relief, which seen to the extent same relief for regularization of the service of the petitioner as grade 4 employee who claims to have been working in the which department?
My lord, education department, in the high school, my lord.
In the high school of what?
Rajdhani Jan High School in the district of Jorhat, my lord.
In the Rajdhani, that what is this? Where do you get it?
My lord,
Randa Nijan. Not Rajdhani Dan.
Randhani Jan, my lord.
Randhani Jan.
Randhani Jan.
Randanijan High School in the district of Jorhat, Assam. This court in the earlier writ petition being WPC 8217 of 2022 by an order dated 08/02/2023 has disposed of the writ petition, directing the respondent number 2 to consider and dispose of the representation made by the petitioner by a speaking order within a period of 2 months from the date of receipt of copy of the order. However, the petitioner appears to have not pursued the matter after after submission of the court's order dated 08/02/2023. Stuff. After after nearly 3 years, huh?
3 years.
From the order of this court, this petition has been filed seeking similar relief, which prima facie, in my view, would not be maintainable. However, on the insistence of London Council, Mr. Gogoi, an opportunity to convince to address again to the court as regards the maintainability of the writ petition is provided. Accordingly, list this matter after.
After 1 week.
Not before this court. You will not be able to convince.
2 weeks, sir.
I'm clear about what is.
After 2 weeks.
Let it 3 weeks.
3 weeks, sir. Highly appreciated.
Try your luck in some other bench.
Well,
Yes.
My lord, this petition has been filed, my lord, challenging the inquiry report, which starts at page 100, the order of my removal, which starts at page 121, and the subsequent advertisement. My lord, there's three facts I'd like to.
Will issue notice?
My lord, there's one submission I would like to state, my lord.
Will issue notice? Nothing.
And my lord,
You have been terminated.
I have been terminated from service, my lord. The reason being, my lord, there was a reason which was that
It was the regular departmental proceedings. After regular departmental proceedings,
my lord.
you have participated.
I had not participated, my lord.
Why?
That's the point, my lord. In fact, this honorable court, my lord,
But notices were given to, so causes were
so
issued to.
causes were given, written statement was furnished. Then there were two writ petitions, my lord. Small details, my lord. I would like to point out.
It's okay, at this stage we'll issue notice.
Then my lord,
Termination, when? What is the order?
my lord, the order is at page 121.
Huh?
Page 121, my lord.
Yes.
Page 121.
What do you want today?
The only observation that I want from this court, my lord,
Huh?
is that if your lordship may kindly come to page 122. 122 for a moment, my lord. This is the advertisement which you have challenged.
No, what observation you want?
My lord, that the final appointment of the academic register should be subject to the outcome of this writ petition. That the academic registrar's appointment by the Gauhati University shall be subject to the outcome of this writ petition.
When you issue notice, that will be always subject to outcome.
My lord, what happens, my lord, the third party rights will be created, my lord. And the fact of the matter remains, my lord, that the petitioner could not cross-examine the prosecution witnesses. It was a liberty which was granted by the Honorable Single Judge on 4th of November 2025.
You have not been allowed or what?
No, has not, as my lord.
Since you have not participated,
my lord,
how can you claim that you are not allowed to
no, my lord,
cross-examine?
there's a writ petition, there's a writ.
What is denied to you?
Initially it was denied to me.
Despite you are asking, it was denied.
Yes, initially it was denied to me.
So as where?
In my lord, but the order, my lord.
Not the order.
My lord, the letter.
Where you have denied.
Yes, my lord, we kindly.
And how you are denied?
Page 58, my lord. Page 58.
Page
58. Page 58 follows the order of this Honorable Single Judge at page 48, my lord. If your lordship can kindly come to page 58. I, Professor so-and-so, academic register under suspension.
See, when you have not participated, how can you ask for a cross-examine?
That's the reason, my lord. I'll trouble this court only for 2 minutes, my lord, not beyond that, my lord. No. Just 2 minutes, my lord. But there are background facts, my lord, which might make it.
Heard, Mr.
M. Sharma, my lord.
My lord, one writ appeal is pending.
It's true, my lord. I mentioned
subject matter.
No, not same subject matter. Not same subject matter, my lord.
My lord, regarding the judgment of the Honorable Single Judge. There, my lord, my learned friend is against that single judge's judgment.
I can satisfy the
challenge the same termination order.
No.
Single judge's judgment, my lord. In the writ appeal, that single judge's judgment was, my lord, challenged. Here, single judge's judgment in support of that, my lord, this petition has been filed.
No, my lord, no.
My lord, at least, my lord.
No, single bench judgment, what does it say?
Single judge.
Was the challenge is the termination?
No. In the single judge's order, which was passed in the month of November last year.
What was the challenge?
My lord, the challenge was to the inquiry report, which was published in the year 2025. Now, what had happened? That inquiry report was forwarded.
What is the order of the single judge?
My lord,
tell us, what is the
page? So, what the Honorable Single Judge did was the Honorable Single Judge remanded the matter to the stage of cross-examination of the prosecution witnesses. Now, that writ petition was preferred by the petitioner, my lord, because the disciplinary authority had already accepted the inquiry report and the inquiry officer had recommended my termination. He cannot do that under the rules. We challenged that before the learned single judge. The learned single judge in the month of November, my lord, 4/11/2025, set the clock back till the stage of cross-examination of the prosecution witnesses. Now, being aggrieved by that, I had preferred a writ appeal, challenging the fact that the entire disciplinary proceeding should be taken back to the stage of issuance of show cause, because I have indicated in my humble submission enough example of bias, my lord.
How can you set the clock back?
No, my lord, this honorable court can always do that, my lord.
It is impossible.
No, till that time, there was no conclusion of the
It amounts to setting the clock back, but you cannot set back the clock.
Then your lordship can stop the clock. That is what I'm seeking right now.
Do it.
Then your lordship will only hold assuming this writ appeal, which is on a separate subject matter, and this writ petition, my lord, I'm submitting on oath, is on a separate subject matter. The
What is
causes-
this then?
This writ petition is for setting aside the removal order and the inquiry or officer's
So
report.
inquiry report was already put to challenge.
It was put to challenge. Subsequently, there was another inquiry report, which they proceeded in the absence
Okay,
of my.
and Mr. MP,
M. Sharma, my lord.
M. Sharma, learned counsel for the petitioner. What is that inquiry report?
My lord, the inquiry report starts at.
Challenge made in this writ petition
My lord, the inquiry.
is to the inquiry report where?
Dated 25/11/2025.
Where it
page
is?
99, my lord. Page
Where it
90
is?
Page 99.
Huh.
It starts from page 100. The annexure starts from page 99. Annexure 9, page 99 is the forwarding, my lord, of the inquiry report.
Inquiry report dated
25/11/2025.
25/11/2025 by the, oh,
My lord, by the inquiry officer, my lord.
by the,
By the
Huh?
inquiry officer, the findings, my lord, will be at page 117,
by the inquiry officer.
my lord.
Hmm.
The findings are at 117, my lord.
Whereby the charges, charges of misconduct
My lord.
against the petitioner is found to be, is held to be proved.
In the absence of my cross-examination, my lord, that observation will be relevant, my lord.
No, and the order dated
Order dated, my lord, 22/2026 at page 121.
and the communication dated 20/02/2026
Six, my lord. At
as by the
120,
registered Gauhati University.
my lord.
Informing that the petitioner is removed from service of academic register, Gauhati University with immediate effect pursuant to the discipline, pursuant to the,
Inquiry report.
in terms of the findings and conclusion of the report of the inquiry inquiry officer.
Right.
Listen, issue notice returnable by 4 weeks.
Subsequently, there was.
You are appearing for all.
Respondent number 1, 2, 3, and 5.
Who else are there? Since Mr. Huh? 1, 2?
1, 2, 3, and 5.
Okay. You can appear for 4 also, inquiry officer.
Sir, so I should not
This is
represent.
by you, appointed by you only.
Yes, my lord, they are under.
Since,
It's not by name, you appear. Since Mr. P.J. Fukon, the Standing Council, Gauhati University, enters appearance and accepts notice on behalf of all the respondents, no formal notice need be served. However, extra copies be furnished to the London Standing Council.
On the next day, my lord, I'll be on the aspect of maintainability. Since writ appeal is pending,
Yes, yes.
one propriety requires,
It's
one
always-
IS should be filed regarding the subsequent
We're
developments.
not saying anything. You just
Propriety-
issued notice. You, whatever you want. You are
Okay.
not barred.
If I may pray for a shorter date, my lord, otherwise the matter can.
4 weeks,
Third party rights might be created, my lord.
3 weeks.
Submission, my lord.
3 weeks.
Can I pray for a fixed date, my lord, in my.
3 weeks, give the fixed date.
That writ appeal has been fixed on 21st April, my lord.
That is on a separate footing altogether, my lord. I can
My lord,
clarify this court, my lord.
there is a
submitted-
I tell link,
Pre-
my lord.
after 21st. Who has filed the writ appeal?
We have filed the writ appeal, my lord. We have filed the writ appeal to take the proceedings back to the stage of issuance of show cause. This is a subsequent cause of action which we have filed, challenged. And we have mentioned about the writ appeal in the writ petition. my
So
lord.
your
You are
lordship
saying
would
that
have to go through the entire writ
it should not
appeal.
be from the stage of cross-examination.
My lord, because we
You
have.
are saying
indi-
from the
Yes, my lord, because of.
de novo, you want the de novo.
My lord, because we have indicated enough instances of bias on the part of the disciplinary authority and the inquiry officer.
It's very difficult.
It might be difficult, my lord, but we have not touched upon the subject matter of that writ appeal, my lord. We'll never do that, my lord. This will
Anyway, we'll
but the
see,
fact
we'll
of the
see.
matter remains, my lord.
We'll see.
If your lordship can kindly observe
What?
that the appointment of the academic registrar, it just for some comfort
That
to the
can't be
petitioner,
We
my lord.
are not convinced.
My lord, some comfort, my lord, because what has happened even after the liberty which was
But
granted.
always, we, as you said, normally, it's not normally, it's not it is impossible to turn that clock back.
My lord,
In certain circumstances,
true, my lord,
we passed an order
true, my lord.
which amounts to
Turning the clock back.
turn
my
the
lord.
clock back. But practically, it cannot be done.
We can stop the clock, my lord. That is what I'm.
No.
Because my entire service.
Neither we
career
can
is at
stop
stake.
the clock.
My entire career is at stake. I was not given the right to cross-examine, my lord.
Since we are not-
Admitted. The
The
admitted fact.
maintainability aspect
We'll
is
see,
there,
we'll
my lord.
see.
So,
My lord, I'm grateful, my lord.
most of them.
Second April.
May I plead your lordship?
Yes.
Your lordship, learned counsel, Mr. B. Pathak is on legs. Therefore, I pray that.
What you want?
Your lordship, I am seeking a direction from this honorable court so that my application for permanent medical registration may be allowed because the application is pending for more than 6 months, 18 days till today, sir.
Obtain instruction?
Yes, my lord, I have to obtain, in
Ah.
fact, my lord, the preliminary instruction I have received that, my lord, there is certain the circular or guideline from the NMC, National Medical Commission, that, my lord, during COVID period, the petitioner was undergoing certain courses. So regarding that courses, the details has been sought for. So they are examining the matter. So I will obtain up-to-date instruction. Your lordship may fix it after 2 weeks, my lord. In the meantime, they are examining the matter, my lord.
May I further submit your lordship? Your lordship, there has, they have issued a
We'll see,
circular
we'll see
on the
after
date
te-
of.
We'll see after, let them obtain instruction. We'll
The
see
issue has
after
already
10
been
10 days.
resolved.
10 days.
Next
10
week,
days, we'll see. After 10 days, let them obtain the latest.
because your lordship, I'm
Current
an
state-
aspirant
I mean,
this graduation medical examination.
10 days, that's what I'm saying. We understand, that's why. Right?
Yes, my lord.
You have waited for so many days. Why not another 10 days? Let us see. Isn't it?
Yes, my lord, and it is under consideration, my lord. That they
He
are-
said it's under consideration. Heard, Mr.
V. Jammer,
B. Jammer,
Jammer.
learned counsel for the petitioner. Agreed by the non-issuance of permanent medical registration certificate.
Yes, your lordship.
This present application is instituted for a direction to issue the said certificate on the ground that all the required, all the necessary what do you have undergone?
Ukraine for medical.
Huh?
I'm a foreign medical graduate, your lordship.
On the ground that the petitioner has undergone what is compulsory rotating medical internship?
It is a mandatory internship.
Being the foreign, what is it? Foreign medical graduate examination. List of next paragraph. Considering. No, Mr.
DP Bora.
DP Bora, and standing counsel,
Yes, my lord. Health department.
health and family welfare.
DK Boydha, my lord, standing counsel NMC, my lord, respondent 3.
And DK Bodio, standing counsel NMC. NMC is what?
National Medical Commission.
National Medical Commission. Have jointly submitted that the case of the petitioner is under consideration.
Yes, my lord.
Mr. Considering above. Considering submissions of learned standing councils and considering and also the issue raised in this petition, let this matter be listed after 10 days. On the next date, Learned Standing Council, so and so, give their name, to place the latest status of the matter.
Obliged, my lord.
Item 13.
Yes.
May I please announce? My lord, I am the headmaster of, in-charge headmaster of Commercial High School in the district of Kachar. I was appointed in graduate scale on 3/11/1993. Page 16.
Where's the impugn order?
Impugn order, my lord, page 22.
You are Prasenjit Singha.
Yes.
Singha.
Yes.
Huh?
Yes, I am Proceedings.
You are eligible.
I am eligible and my academic career is better than the respondent number
We
4.
don't know.
My lord.
We don't know.
That's why, my lord.
This has been considered by the authorities. It's not only particular person. I mean, one person. As many as 100 and, no, as many as 37 plus 5.
Yes.
40,
But I am
42%.
I am only
right?
for respondent number 4. I am only so far it relates to respondent number 4. That is, my lord, page 23, serial number 35. Bottom.
KH Ratan Kumar Singha.
Yes.
What is KH?
My case is this, my lord.
KH.
It is
Ratan Kumar
the
Singha.
surname.
What is this KH?
That I also do not know.
You don't know your, I mean, your adversary.
He is not my client.
Huh?
He is not my client.
No, your client must know who he is.
He also knows. These are actually, so far I know, these are
Okay, we'll
ancestral
see.
title.
It has been by
carry
the
out
common, I mean, promotion. It's a promotion order.
Yes, it is promotion order.
Selection. The
Yes.
combination is State Selection Board. Selection Board has undertaken
No.
selection
It
process.
was done by the inspector of schools after perusal of necessary documents.
Let us see. We'll issue notice at best.
And my lord, since last 6 years, I have been discharging my duties as the in-charge headmaster.
No, it too.
So I have gathered vast experience with financial powers also. So when there is no formal interview, only
Of what? In charge.
no. At the time of appointment, there was no formal interview. Only papers were verified. Now my submission is this: my
There must be a written examination.
that was not there. So if on the basis of the mark sheets and other
But in any
purposes-
case, this has been made under, as per the rules. Selection has been made by rule, made under the rules.
rules,
Obviously, there is a selection board.
selection board is there.
Okay,
But-
we'll issue notice, nothing else.
But till today I am discharging as headmaster.
See, you are claiming which headmaster, which school?
A Commonwealth
Kamleshwari High School.
Yeah.
Right?
Yes.
And he has been
He has been also appointed.
place
in
of
the-
posting.
He is the assistant teacher of another school. He is the assistant teacher
You are?
of Salepur L. Devi Manipuri High School. So he is the assistant teacher. I was all along since the 6 years in charge headmaster.
You are what?
I am in charge headmaster.
No, what? You are substantive post?
Substantive was senior most assistant teacher earlier, before appointment. But since the 6 years, I am the in charge headmaster.
But this respond number 4
Yeah.
was not from your school.
No. From
Then?
another school.
How
From
do you know
another
that he's junior or senior to you?
No, he is from
He is from Salepur L.
LP.
Devi Manipuri High School,
Yes,
promoted, selected as headmaster
yes.
and posted
And
to your
posted
school.
At Commonwealth.
So how you equate, I mean, how you are equal?
No, my question is whether he is transferred or not. But how, when my qualifications are better, academic career is better, I am discharging my.
That is the job of the selection board.
But if the selection board commits something arbitrary,
That's why we'll see whether there is a arbitrariness, illegality, whether it is followed the rule or violated the rule. We'll see. Let them
Then, my
respond.
lord, one humble
Heard,
prayer.
Mr. M.U.
Till then,
Muhammad,
the status quo is until
learned counsel for the petitioner. Next para. Challenge made in this writ petition is to the order dated 11/03/2026 issued by the Director of Secondary Education, Assam, whereby as many as 42 assistant teachers have been promoted, including the respondent number 4, have been promoted to the post of regular headmaster. List of next para. It is the case of the petitioner that he or she, he has been discharging the service of
the headmaster of
service of in charge headmaster head.
yeah, Provincial High School.
Why you have said headmistress?
It is my lord typing mistake.
Headmaster of Kamleswari High School, in the district of Kachar since 2020. For more than 5 years. However, the respondent authorities have illegally deprived the petitioner from promotion from promotion to the post of headmaster of the said school, whereas the respondent number 4 has been promoted to the regular post of headmaster and posted in the school of the petitioner. List of it is further contents that the petitioner is the senior most assistant teacher, whereas the respondent number 4 is
from another school.
Is
And
simply an assistant teacher
and never
from another school.
worked as in charge headmaster.
List of next para. Should I record my view? Having considered the submissions of learned counsel Mr. M.U. Muhammad and also on perusal of the materials available on record, this court prima facie of the view that a proper selection process appears to have been undertaken for promotion of the promotion to the post of regular headmaster of various schools, wherein as many as 42 assistant teachers have been promoted to the post of regular headmaster. List of nothing has been indicated how the selection process culminating into the impugn order of promotion
No. That is clear, my
has
lord.
been
Some documents are called for.
has been indicated, except to project that the petitioner has been working since has been working as in charge headmaster
Since
of the Kamleswar High School, which by itself may not be may not be a ground to challenge the promotion of the assistant headmasters who would be otherwise and eligible and entitled to be promoted to the post of regular headmaster. Of course, unless the promotion is in violation of the recruitment, provision of recruitment rules, or the petitioner is unfairly not considered. Mr. However, to provide an opportunity to the respondents to have some to respond to the claim of the petitioner, I deem it appropriate to issue notice at this stage. Accordingly, issue notice returnable by 4 weeks, as Mr. P.P. Datta, London Standing Council, Secondary Education, enters appearance and accepts notice on behalf of all the respondents, no formal notice. All the respondent board, 1, 2, and 3, no formal notice need be served. However, extra copies be furnished to the Land Council for the petition, Land Council of, to the Land Standing Council, petition, Land Council for the petitioners to take steps for service of notice upon respondent number or by speed post as well as usual process within 3 working days.
May the timetable may be upgraded. Time may can be upgraded.
4 weeks.
3 weeks, let it be 3 weeks.
4 weeks.
Petition is late merit lordship. No.
I have read your petition.
No fundamental.
I had a privilege and pursuant to read your petition last night, meticulously. So there's nothing, no grounds, nothing. Yes. I think this is also same. Same.
Same, my lord.
Same
Fixed
order.
on 31st of March. The other matters are fixed on 31st of March.
Same order.
Same order, my lord. The petitioner here is headmaster of Pandu College, but it can be page 113, my lord. Lordship notice was issued, returnable 4 weeks, lordship. Lordship, in that case, lordship, returnable 4 weeks, lordship.
But the challenge is the same order.
Same order, same lordship. 113.
Where is the order?
This one from 113, lordship. 113, madam. 113.
113. No, I'm asking
The impugn order.
Impugn order.
Impugn order, my lord, is it page
which?
85, madam.
Page 85. 85.
It starts from page 85, the impugn order.
85. This is the, what is it?
He is the head assistant of Pandu College, madam. And his grade pay was granted from 25 to 2020. And they have sought to recover, my lord. So the other petitioners, they have filed rate petitions. So this honorable court.
It's okay. Let me understand your case. What does it say? This 185? Actually, 85, page
85 says that the grade pay which was granted, it should not be that grade pay, it should be lesser than that. So the secretary had written to the director higher education to verify, and thereafter, if any excess payment has been made, to recover. So accordingly, the director at page 86 has issued a letter to all
grade pay or scale of pay?
The grade payment.
Is that recovery excess amount and follow the, okay. You are what?
I'm head assistant.
Head assistant. Challenge made in this writ petition. Are you ready? Challenge made in this writ petition. Heard Mr. Count, learned counsel for the petitioner. Challenge made in next para. Challenge made in this writ petition is to the communication dated 06/11/2025 issued by the secretary to the government of higher education department, whereby excess amount alleged to have been drawn by the petitioner as great pay,
Yes, my lord.
as great pay is sought to be recovered. That's all.
The consequent orders are there, but this is the first order, my lord.
Then
Then, my lord, 29/12/25.
where it is?
By Director of Higher Education,
Page.
page 86.
Then
Then, my lord,
what is the consequence final order?
the final order is of the Treasury, that is,
And the and other consequential orders, including
Page 92.
other consequential as well as page 90.
92,
Ah,
and also page 91. 91 and 92.
what is the final and
Final is 12/2/26, my lord. This is by the Treasury officer.
and the letter to refund, a letter dated 02/02/2026 issued by the principal Pandu College to the petitioner to refund the excess amount drawn and the as well as what is this 92?
92, my lord. By the Treasury officer.
And letter dated 12/02/2026 by the Treasury officer to take steps for recovery of the excess roll of great pay from the petitioner. Please stop. Issue notice, returnable by 4 weeks. Is Mr. Who else are appearing? All of you? All the respondents are, no, Pandu College.
I am for 1, 2, and 4, Lordship.
Since Mr. D. Upamani, Learned Standing Council, secondary education, higher education, and
Number EN5.
and Mr. and HLE, Learned Standing Council, Finance Department for respondent number 1. No, except enters appearance and accepts notice on behalf of respondent 1, 2, 3, 4, and 5. No formal notice need be served. However, extra copies, write both their name, both their names. Extra copies, so and so, so and so. Are you getting me, madam? It's all right. Okay. Well, and counsel for the petitioners to take steps for service of notice of respondent 6 by speed first as well as usual process. Yes, then.
That I pray that page 115, similar order may be passed, my lord.
115.
Having regard to the projection made by the petitioner, it is hereby directed
No recovery
that no recovery shall be made.
of excess to Lordship.
Page 115, last para, my lord.
Similar,
Similar order.
same college.
He is from different college, but the petitioner is from Pandu College. Here the petitioner was from BH College, my lord. BH College, Howli.
Having considered that this court in a similar matter by the order dated 09/03/2026 in WPC 1315 of 2026 has directed the respondents to not make further recovery from the petitioners pay in the writ petition till the next returnable date. It is provided that no interim, it is provided that No further recovery shall be made from the,
This drawn amount.
no
From the
further,
excess.
no further recovery. From the pay of the petitioner shall be made on-
Excess drawn amount.
on excess
Royal of salary.
royal of great pay. Till the returnable date.
No, it says, my lord, further recovery from the petitioner's pay. Excess royal of.
What is this? No further recovery, that's all, nothing. No further recovery shall be made from the petitioner's pay till the next returnable date. That's all.
May I take a lordship indulgence? But item 62 supplementary, exactly same matter, only party's name is the school's name are different.
Ah,
Item 13, just 13 order maybe.
same order. School is
School is, that is, little different.
same impugn order.
Same, maybe a same if you know.
62, same impugn order. Huh? Is that of
School name
item
is
13,
Balika.
Balika. Name of the petitioner will be different, nay? Is name of the school
School and
And-
parties are different.
and respondent number 4 or 3.
Yes, 4 is same.
Same.
But party name is different, but he is also student number 4.
No, respondent, name of the respondent number 4 is different. In a school, which is school?
Balika Vidyalaya.
Your school is Balika.
Yes,
Yes.
yes.
Okay.
It is the matter of
Best-
regular headmaster.
Best is regular headmaster.
Same order.
Same.
That's fine. Only name of the respondent
Yeah.
and the name of the school will be different. Otherwise, impugn order is same. Huh? And other, observation will be same.
My lord said was given.
You want to interim, you want that it should be granted interim order. Huh? Why?
Already, one person, respondent number 4 is holding the post, my lord.
So,
He has.
And notice has not served to him
In
also.
my case, I don't know others' case.
just
In my
because
case-
he's holding a post, can we not pass interim order?
But after due selection, he has selected and holding the person, holding the post.
On the prayer of Mr. Yusuf Sharma, on the submission of Mr. U. Sharma, learned standing council of what?
Secondary education.
Secondary education. Petitioner shall be allowed to continue as headmaster.
No, ma. Yes, no. Respondent
Yes or
number
no?
4. Respondent number 4, my lord.
Yes or no?
Respondent number 4 should be allowed to.
Yes,
hold
but
the
what your lordship has.
He's
Whatever
sticking,
things the open
he's
court-
praying for allowed to continue the petitioner. What do you say?
No,
My
his
lord,
lordship has
petitioner is
pronounced the matter.
Petitioner is the in charge headmaster, my lord here.
And I'm just on lighter note.
My
Anyway,
lord, I was hard to.
I've already passed the order. This is what I'm trying to indicate you. That's why he's seeking similar order, same impugn order, same order, what he say, only they accept the, only the difference is the school and the name of the respondent. That's all.
Okay.
61. Motion.
May I please the lordship?
Yes.
The matter came up day before, my lord.
Huh?
Matter came up day before, my lord.
Why?
Today it was fixed, my lord.
Yes. So,
My lord, it was challenging the impugn order. That is page 24, my lord, where inspector of school was given in charge. My lord, that is all right, no problem, my lord.
huh?
Subsequently, inspector of school, my lord, issued respondent number 5, appointed respondent number 5 as academic principal. Now, my lord, my case is paragraph number 8 only, my lord. If my case is paragraph number 8 only. Only
Paragraph number?
8, I will read, my lord. Paragraph number 8 of my revision, my lord. Page 8, right. Only this will do, my lord. But if I have anything, my lord. That the case of the petitioner is that among the teacher, he is entitled to hold the post of in charge because he is not only having qualification in terms of degree as well as length of service. 2 other who were senior to the petitioner, but they are not master degree holder. Apart from that, there is no standing select list for the post of regular teacher. That is important, madam. Regular principal. Under the circumstances, the petitioner legally entitled to be appointed as in charge principal of Sri Gauri Higher Secondary School. The petitioner also submitted representative. That is pending, my lord. On 19/1/2026, before the respondent number 3 for necessary consideration for allowing to hold the charge of principal on retirement of Masuk Ahmed on 31.
How you are legally entitled to be
Legally-
appointed as in charge?
Legally-
Where is the rule?
No, my lord.
What is the rule for regulating
Yes,
appointment
yes,
on
There-
in charge basis?
In charge, there is actually direct,
Then-
my lord, the rule is,
then-
I have legitimate expectation, my lord.
Huh?
One is since till regular headmaster is or principal is not selected, my lord. Generally, senior most one who is
See, principal in charge is given to inspector of school.
yes.
Then
Now, my lord, inspector of school, inspector that definitely is a temporary arrangement.
heard Mr. So and so and counsel for the petitioner.
The last part of this paragraph, my lord, that is important, my lord. Oh, my lord, last part, that is important. Only few lines, my lord. As he was expecting positive response, unfortunately, response number 3, that is the director, my lord, impugn order dated 5.
Where is the order of allowing the private respondent to hold the
That is not there in the last line I have mentioned, my lord. My lord, can you see?
it's not there.
No order could be collected despite of due diligence, my lord. I made a specific statement, my lord, down below, my lord. Further, it has been learned that the respondent number 4 has appointed respondent number 5 as academic and officer in charge, though no such order could be collected despite of due diligence, my lord. Well, at the time of filing, my lord, that order could not be collected, my lord. Otherwise, that would have been input here directly, my lord.
Heard
The
Mr.
same has been intentionally done to.
Heard Mr.
Yes, my name is A. Chaudhary, my lord.
A. Chaudhary, learn counsel for the petitioner. The
Only thing my
petitioner
representative-
challenges the order dated 05/02/2026 passed by the Director of Secondary Education, Assam, by which the Inspector of School, SDC, Sribhumi, is allowed to act as principal in charge of Sri Gauri HS School in the district of Sribhumi. With financial power in terms of the FR 49 within bracket C, bracket close, huh? Well, next paragraph. Well, moving this writ petition, Mr. Chaudhary submits that he's basically he's not pressing the challenge to the order dated 05/02/2026 by which the inspector of the school has been allowed to act as principal in charge. However, he would challenge the where it is, where you have said?
Page 9, last portion, my lord.
Ah,
Further, it has been learned.
challenge the appointment of respondent number 5 as academic and officer in charge. Although no copy of the order is annexed in the writ petition. Please step. Next paragraph. What to do?
I mean, your worship, my lord, alternative prayer, my lord. My representation is pending, my lord. As per me. Oh, my lord, since I have, despite of
It is the
diligence, I
case of
put
the
to-
petitioner
No, my lord, then,
that the petitioner is the senior most.
yes, I believe I am the senior most because I have.
You
given the
believe?
chart also, yes. Among
Case of the petitioner that
the existing.
he or she
He, my lord.
is the senior most what?
A senior most assistant teacher, my lord.
Senior most assistant teacher of
Sri Gauri,
Sri Gauri
yes, my lord.
SSC school.
Yes.
Therefore, he is legally entitled to be appointed as in charge,
So to be considered as intern.
legally entitled to be appointed as in charge principal,
Yes, madam.
list of principal of the said school, list of. And if not, at least the in charge of
Yes.
academic affairs,
Yes.
which has been allowed to the, which has been allowed to be held by the, to be held by the, sorry, to be held by the respond number 5.
Yes, madam.
Respond number
Yes.
5. Next para. Issue notice returnable by 4 weeks. As Mr. So-and-so, PP Datta, learned counsel for the petitioner. Learned standing counsel, elementary. Secondary education enters appearance, accepts notice on behalf of respondent number 1 to 4. Then MS, DD Barpa. Additional senior government advocate have enters appearance and accepts notice on behalf of respondent 1 to 4. No formal notice need be served. However, extra copies. Petitioners to take steps for service of notice upon respondent number 5.
Yes.
By speed post as well as using process within 3 working days.
Madam. 2 to 4.
Anything else?
Madam.
Anything else?
Madam. 2 to 4. That will do.
Problem. 5 minutes. 5 minutes, huh?
Admission hearing process. 16 now. Book sign by Oh, କରିବ ନି କି? ପିଟିସନ କାଉଣ୍ଟ କରିବ। ଓ ସେମିତି ଓ ଆପ Problem is minor saving was stopped, minor. On the basis of the interim order passed earlier. Now that interim order was passed on a wrong premise, man. If your lordship kindly takes up that order dated 25/5/2022. Otherwise, my lord, pleadings are complete in this case. Order dated 25/5/2022.
Further?
Order dated minus 25/5/2022.
25?
25th of May 22.
Twenty-fifth. There is no order.
My lord, what is recorded here is this, my lord. If I may read, my lord, that will be the paragraph.
No, page. I mean, order dated.
Well, I know order sheet, my lord. The order
Which
sheet
date, sir?
25/5/2022.
202.
2022. Order passed by this honorable court, my lord.
Yes.
My lord, it is stated that the respondent number 7, Naren Chandra Mahato, had left the school before the order of provincialization, and the names of the respondent number 8 and 9, namely Visnu Hatra and Nandeswar Kurmi, are not included in the dice code. But this second part is wrong, man. This is actually, my lord, not in keeping with the records, my lord. I am not saying names of respondent number 8 and 9, Visnu Hatra, whom I represent, my lord, and Nandeswar Kurmi are not included in the dice code. Their names are very much included in dice code. They have been selected and they have rendered that statutory period of 6 years, no? And they are selected and they were appointed. But because of this order, my lord,
since May 2023, my lord, my salary has been stopped and the matter has been pending since.
Who is for the petitioner?
Well, I saw him, my lord, he was here. I don't know where he's gone. The respondent authority has also filed affidavit in our.
Saying what?
My lord.
What is your stand? Respondent authority?
Based on the enrollment position of the school of 5 teachers were provincialized.
Ah,
Oh, where the petitioner name was not recommended lordship,
ah.
we have provincialized the rest of the teachers lordship. There were one.
May I please, Lord? I apologize for the inconvenience. I was outside. Here, my matter pertains to provincialization of services, my lord. The other side has, my lord, Director of Elementary Education has filed their affidavit, my lord. But, my lord, they are not annexing any records. They are making some affirmance. So the minutes of the DLC and all these records are required, my lord.
So according to this respondent 7, 8, and 9,
Yes,
they don't have the UDIC code.
my lord, one person do not have, my lord, UDIC code. And apart from the another is Hindi. Hindi is a special subject matter. I am in language as per the 2017 Act.
Hindi is not language.
Hindi is a special subject, my lord.
It's not a language.
It is not a language as per the Act.
It's a national language.
No, my lord, it's an additional compulsory subject that it is mentioned.
What are the languages?
My lord,
If the
it
Hindi
is,
is not
so
language.
far as the language is concerned, my lord, there is also a dispute I have gone through, my lord, under the 2017 Act because the language is not defined. And as per the mandate of section 3111, my lord, one social science, one social science, one maths and science, and one languages. Because there are, my lord, more than one languages. So, my lord, if we go through the act, my lord,
What is your ground?
my lord, that one income, my lord, private respondent number 7, his name is not available in my lord 2019 dice, my lord. And thereafter, my lord, Hindi is a special subject. So first, my lord, the test of section 3111 is required to be fulfilled. Language is required to be appointed first because as per the mandate of the section 3111, I am being a language, I have been left out in spite of me, my lord, some other.
What is your language?
English, my lord. That's why I'm saying, and my lord, that
Hindi is not a language according to you.
my lord, as per the act.
As per the act.
Act per the act.
What is the language? English?
English is, my lord, that's why I'm saying, my lord, there is a dispute because there is language is not defined. There is a, my lord, pro forma wherein, my lord, as regards the salary, this is an index is there. There are, my lord, Hindi slash languages slash Arabic and all this. Arabic and, my lord, Sanskrit, these are special subject that has been mentioned in the act very specifically. So for the respondent number 10 is concerned, my lord, he is junior to me and he has given his resignation himself. That also I have, my lord, annexed. Headmaster has communicated. He said that, my lord, he had been, my lord, engaged. He, my lord, got appointed in some another school. That, my lord, had that particular teacher is junior to me. So that's why, my lord, I'm saying this DLC minutes and all is required because so far the section 3111, my lord, the 2000 Act is concerned, provincialization on basis of the, my lord, subject of. They have not annexed any records. Only we can
Mr.
we can ask, my lord.
That is counsel for the petitioners. Petitioner.
Petitioner, my lord.
We also heard Mr. P.N. Sharma, that is standing counsel, Elementary Education Department, as well as Mr. B.D. Goswami, that is counsel for
8 and 9. Respondent 8.
7 and 8, 7, 8. Who is for 7? The Mr. Correspondent and Mr. B and Mr. as well as Mr. Swainson. B.D. Goswami for respondent 8 and 9. So what is your stand?
He has already left, man. He joined some other job, so that course is like
So you have nothing to do. What about you? Saying what? And then you have
been selected.
Your name is there.
Madam?
2019
Yes,
UPIC.
madam. Everything is there. We qualify in all respect.
No, my lord, so far.
And what about the language? You are Hindi.
And also, I
Seven
have,
is
There are
Hindi.
cases, my
Hindi.
number of orders have been
Hindi.
passed by this court.
he is Hindi, my lord. Hindi and my lord, he's.
Seven is what? Seven is
My
what?
lord, they are appearing for perhaps for, 7 is, my lord, he is an assistant teacher, they are saying. But he is junior to me, my lord. Subject.
So
not
he's
mentioned.
out.
He's.
You cannot have any grievance now.
Yes, yes.
No, my lord,
He's no
7
longer
is-
in the shop.
My lord, 7 is also provincialized, my lord.
He said he's no longer there.
Yes. But he's junior to me.
He has left it already. He has left already.
Yes, my lord, he is not in service. But in his place, my lord, provincialization not adjust.
Can you?
Lordship, there is a process.
Why he has been
The
rejected?
name of the petitioner has to be
Sir,
recommended.
why he has been rejected?
There were 3 language teachers, and according to the enrollment position, 2 language teachers were.
Now
qualified.
you are English.
English, my lord.
Now, in that case, Lordship, let my learned friend's client prefer an appeal under section 14 of the Act before the government.
No,
So let the government.
no, my lord. I
No.
am not. Appeal, no, my lord. Record is required here. Appeal is in, my lord, state.
No, what I'm saying, what I'm just suggesting is since you have provincialized the service of the respondent number 7,
Yes.
right? And there's a vacant now. You can provincialize him. His service can be provincialized. You take instruction. I think it's better.
Yes, my lord.
Instead of,
Yes, my lord.
contesting,
Yes.
if there's a vacancy
Yes.
and without disturbing the service of
Yeah,
respondent
exactly,
number 8 and 9,
Exactly.
when there's a vacancy, if you can do
Ultimately,
it.
my lord, ultimately, I want provincialization.
Prefer an appeal only, because there is, otherwise there is a process to come through, routed through the district scrutiny
no.
committee. Instead of going through the district scrutiny committee, if my learned friend, in terms of the section 14 of the Act, prefers an
It's
appeal
okay,
before the government.
sir. You have undertaken,
Lordship.
rejected his case
Lordship.
and provincialized their cases. Therefore, you just say that this, it is pending without going into the, without having a, contesting, allowed to contest each other.
In that case, I will obtain instruction, Lordship.
Kind of, sabbi mare, lati bhi na phute, kind of thing. Is not it?
My salary is also not stopped, it is resumed, my lord.
Huh?
Sab bhi mare, lati bhi na tute, and my
10
salary
days.
is also continued, my lord.
No, you 10 days you obtain the instruction. Or all of them. Having considered that the respondent number 7, whose service has been provincialized as language teacher, is no longer in the service. And the claim of the petitioner is to the effect, a claim of the petitioner is for provincialization of his service as language teacher in terms of the Act of 2017. Mr. P.N. Sharma, Learned Standing Council, is granted 10 days time to obtain instruction as to whether the service of the petitioner can be provincialized in place of the respondent number 7, who had
Resigned.
left the who has resigned. You have resigned.
Resigned.
Who has resigned from the post of language teacher. That's all.
What's been fixed
Place the matter after 10 days. Give the date.
After vacation also.
Because that you are not getting salary. Why you have waited so many days? You could have filed an IA for modification of that order. Anyway, that's why we'll take it up after 10 days.
Yes, ma'am. Yes. Obliged.
Lovely.
Ulumoni Devi.
May I please, your lordship? In this matter, the government has not filed affidavit, lordship, item number 18, lordship. The matter pertains to, lordship, challenging the second SOCOS notice, lordship. Page 42 is the impugned letter.
You have sent it for betting in the year 2000.
some correction, they have added some new facts, Lordship, that I have to bring on record. That I have also done it and sent it for.
Another betting.
Yes, Lordship, may take it up next week, Lordship.
What is the issue?
Lordship.
What is the matter
Matter
about?
pertains to Lordship, page 42 is the impugn order, Lordship. Second focus notice, we have silence, Lordship.
Of what?
I was working as a principal in charge in government Shikshan Mahavidyalaya, Nagaon, Lordship. During my tenure, Lordship, some allegation has been lodged against me by the student and other co-teachers, Lordship. Thereafter, page 33 is the order, Lordship. By order dated 2/4/2022, Lordship, I have exonerated by the secretary, Lordship. Thereafter, again, they have sent a second focus notice to me, Lordship, regarding the same issues. That is the issue, Lordship. Now I have retired from service.
What?
That
Nothing remains. So what do you want now?
Lordship, till there I have no instruction, Lordship.
No, what do you want now?
I think the client has
Let them
also
take instruction, Lordship.
communicated him.
Huh?
Yes, I have communicated, Lordship.
The client has
See,
also.
there was an allegation.
Yes, Lord.
It has been, you have already exonerated him.
Yes, sir. By one order.
And thereafter, certain source code notice has been issued. Now he has been retired. How can you pursue that? Unless it is so serious.
Yes. Lordship may take it up next week.
You obtain instruction.
Lordship.
Huh? Considering the issue, comma, both Mr.
PZ.
Learned Counsel for the petitioner and Mr. B. Chaudhary, Learned Standing Counsel,
SCERT.
SCER. What is this?
Secondary School Education Research Training.
SCER. SCERT. To obtain instruction. This after 10 days. Give the date.
Lordship, in item number 19, Lordship, matter pertains to Lordship pension, Lordship. I have not received pension since 2022. Lordship, I pray for item number 19, Lordship. I pray for taking fresh steps to respondent number 4, Lordship, by way of trustee. And respondent number 5 is not necessary party. He is retired.
Then
from
you
service.
write at the same time, same order. On the prayer of respondent, Mr. Vijay Datta.
Yes, Lordship.
Mr. PJ Datta to take steps for fresh steps for
Yes.
service of notice upon respondent number
4, Lordship.
4 in WPC 3386 of 2024.
And Lordship may strike off respondent number 5, Lordship. He is retired from service.
We'll see.
Lordship. God bless.
Item 20. This matter, my lord.
Yes.
On 29th of January, my lord, can you see the order? Respondent was directed to obtain instruction as to whether my period of suspension.
29,
January,
27 or 29?
29. 27 is also relevant, madam. Because I have filed the writ petition for not providing me the compensatory benefits.
First, the matter partner and prisoner has also been offered. This is the instruction.
Yes. Lordship, the limited instruction I was directed to obtain, but in what manner that his substances has been considered by authority. Lordship, that last but one paragraph, Lordship. At the emolument received by Bhupendra Nath, retired assistant teacher of Badalmari High School, during the period of suspension will be his entitlement, and he shall not be entitled to any other financial or service benefit for the said suspension period. The substantial allowance which the petitioner received, that will be limited to that portion only.
But then you have regularized his service?
Yes, yes.
I mean suspension period.
From the date of his superannuation.
Huh?
He was superannuated during the period of his suspension. But for payment of pension and others, he was reinstatement
with effect from the date of his retirement, Lordship. And he has got the provisional pension on that basis also, Lordship. Now he's for a regular pension. For that
Whatever
regular pension, Lordship, we have regularized his suspension period, but during the subsistence allowance, Lordship, which he got during the period of suspension will be limited to those only. He will not claim in any other benefit.
See, once you have regularized the period of suspension, automatically he'll be entitled to entire amount, consequential amounts.
That discussion is vested on the authority under FR 54, Lordship. Whether it will be counted as a on duty.
Has it been communicated? It
Yes.
doesn't indicate anything.
Yes, Lordship.
See, on the next day list is shall appraise as to whether the petitioner on being acquitted from charge against him in criminal case, the period of suspension undergone has been regularized, and if so, in what manner?
The suspension will be.
The affidavit received by Bhupendra Singh Joinso during the period of suspension will be his entitlement, and he shall not be entitled to any other financial or service benefits for the said suspension period. Although the period of suspension has been regularized.
The suspension allowance.
Regularized for the purpose of regular pension and other thing.
Will be a good. No.
I have not received the.
Then what about the other regular pension?
No, that will be already processed, Lordship.
Huh?
That will be processed, Lordship.
No, since pension proposal release of regular pension has also been processed by the respondent authority. That has been processed long time back. 3 months back, 2 months back. Yes, then who is director of pension? Have you any information? You, Mr. Borua?
No, this is, we do not pay. Accountant General doesn't pay petition. Act of pension will be eligible.
No, there is nothing on. No, you have no role now. You have no role.
I don't have rights. Only the director of pension.
Who is P. Das? Who is P. Das?
Secondary education.
P. Das?
P. Das is for secondary education.
Ah.
Now today I am Lordship representing that.
So, P. Das has said so many things. Huh?
My lord, in my case, no departmental proceeding was initiated as on date, my lord. Therefore.
No, so have you understood?
Yes. If my.
What they have done is, they have regularized the period of your suspension, but then no consequential
benefit.
other benefits, financial benefit, except the entitlement which you have already been given,
Only subsistence.
like the subsistence allowance and all that thing. And this regularization is only for the purpose of,
Continuous
your, the pension,
Yes.
the regular pension and other benefits.
Let me take instruction. Perhaps we may require to challenge this order. Because once.
And any instruction as regards your regular pension?
Regular pension, my lord.
Because last, on
It is
2
under
months
process.
back, they said it has been processed.
Yes, it is under process.
You are receiving the
Provisional also, my lord. I have not yet taken.
heard Mr. So-and-so, learned counsel for the petitioner in terms of the order of this court. Mr. P.P. Datta, learned standing counsel,
Secondary education.
secondary education department, has placed the instruction. To the effect that the period of suspension has been regularized, but the petitioner would be entitled for what he has received during the suspension period and not to any other financial or service benefits. And the regulation of the suspension periods is for the purpose of is for the purpose of pension and other service benefits only. Next paragraph, considering other. No, Mr.
HK Nath.
Huh?
HK Nath.
HK Nath, then counsel for the petitioner. Press for and is granted 2 weeks time to obtain instruction in view of the
will also obtain instruction at stage of hearing.
in view of the
It was item 20.
instruction is placed
How can there be two
by the London Standing Council.
You have clear detail.
Huh?
DPF will be staged by accountant generals. Again, it's not that DPF already been received by him.
They have received already.
I do not have now partial role regarding.
Yes. What do you want? What do you want to say?
Lordship, I have to take instruction, Lordship.
For what?
Whether pension or Lordship, PPO was issued or not, Lordship. It is matter relating to suspension, na?
It is for the, no, learn, MS, DD Burman, learned additional senior government is also directed to obtain instruction as to whether the petitioner has been released with the regular pension and DCRG. No, as to whether the process for payment of regular pension and DCRG has been completed or not. Huh? List after 2 weeks.
May I please? What is this case, my lord? Respondent number, my lord, 4, 5, and 6 have filed affidavit, my lord. But you lordship kindly have a look to the order dated, my lord. 22/10/25, my lord, last order.
Yes.
Several occasions, they took time, my lord. Respondent number 2 and 3 have not filed affidavit, my lord.
Who is 2 and 3?
2 and 3, government, RMSC. 2 and 3, quality.
B. Sudhirivas, my lord,
RMSA,
my lord.
Managing Director, Adrasa Vidyalaya Sangathan. What is this?
RMSA is at P9, but P9.
Huh?
P9 is there for RMSA, but
P. Nayak is lost. I have not seen him since last 2 weeks.
RMSC.
Yes, RMS. Yes. You are supposed to file affidavit.
Lordship, it was, at that time I was also handling PTC. RMSA, Lordship, I have not received any instruction.
There is an order last on 22/10/2025. If no affidavit is filed, it will proceed. What is your matter?
Look, my lord, the
About-
petitioners, my lord, petitioners were appointed as graduate teacher of Adarsh Vidyalaya. After they were selected, they were appointed. Thereafter, my lord, suddenly they joined, my lord. Suddenly, my lord, what happened? The BTC has cancelled their appointment letters. This is, my lord, the case.
Who is the appointing authority? BTC.
BTC, my lord.
Why you have cancelled?
Also, we have filed a
My lord,
affidavit.
BTC has, my lord,
In terms of direction.
BTC have filed affidavit, my lord. Their
RMS.
contention is that, my lord, they were
Direction issued by RMSA.
Yes, my lord.
Yes.
On the basis of.
Yes, then why you have given a direction? After due selection process. It is through the advertisement. Is it through advertisement?
Yes, my lord. My lord.
But it is a written examination was there.
No, my lord. Actually, after applying, my lord, they were called for.
Interview.
Yes, my lord.
Ah.
They appeared, my lord. Official list was published. It was approved by the BTC authority, my lord.
For a period of
11 months.
11 months. When it was?
My lord, it was on
2022.
my lord. But though it was
Present
contextual,
teachers.
my lord,
Hmm.
but there's a condition that if their service is satisfied, that they will continue, my lord. Generally, my lord, all the.
This is under the RMSA. The appointment was under the RMSA.
Yes, my
Though
lord.
in a but yes,
Annexure 5, page 25,
page.
25, my lord.
Hmm.
Lordship, clause C. The engagement shall be made purely on contractual basis for a period of 11 months with effect from his or date of joining. Annual performance appraisal will be conducted every year by the authority. Yearly extension of service within the period will be based on
Where is the cancellation?
My lord, cancellation, my lord,
1 month.
at page, my lord, 43, my lord, 42, 41 is, my lord, first one, my lord, 41, answer 8.
Hmm.
After a month or so.
After 1 month, my lord, they have worked for 1 month, my lord, thereafter, my lord, they have cancelled this process, my lord.
Affidavit দিব লাগিব মই আমিয়ে কৈছো
Yes, what to do? Why this has been cancelled? You just said that is it as per the direction of the RMSA you have cancelled. You are the one who has cancelled it.
Yes, ma'am. Unfortunately, I don't have a copy of the affidavit.
What chance, it is from the affidavit, Lordship.
Okay, heard, mister.
Islam.
Although order was passed that we will proceed, but then we need to know what is the reason. Wrongly or rightly, there was appears to have been a decision or direction by the RMSA to cancel. All right. Heard, mister.
Islam.
Yes, Land Counsel for the petitioner. Although this court on 22/10/2025 granted last chance to respond number 2 and 3. RMSA, for file to file affidavit dwelling which the court would proceed to decide the matter on the basis of materials available on record, Mr. B. Chaudhary, learned standing counsel, RMSA. Prays that he may be granted. No, considering the matter, considering the issue involved in the present petition, the response of the RMSA would be required for a record for proper adjudication of the matter. So accordingly, as prayed for and as spread for by Mr. B. Chaudhry, Learned Standing Council, RMC. Further 2 weeks' time is granted to file affidavit, to file response. As a last chance, huh? As a last chance. File response, huh? Please, it is made clear that no further time will be granted
My lord,
on the next date.
date may be fixed, my lord.
Give the date. What is the?
After the diog, visor pisot diog na? Visor pisot diog na, kindly.
Right.
Your Lords.
Yes.
Lordship, pleased to see the last order dated 29th of January 2026. The department is supposed to get instruction, Lordship, as to why the petitioner is not engaged. Lordship. 29/1/2026.
Yes.
The instruction, we have received our instructions and the instructions are very similar to the affidavit that we have filed, Your Lordship. So we stand by our affidavit, Your Lordship.
What does it say?
So it says that because the earlier act was repealed and a new act has come into 2017. Under that act, Your Lordship, the petitioner does not fulfill the criteria, Your Lordship, because for provincialization in the third post, the enrollment of the students has to exceed 150, Your Lordship. So that enrollment is not there, for which we are unable to provincialize the petitioner, Your Lordship.
This is not, he is not eligible to be forbidden.
Under 3(9), Your Lordship.
3(9).
Yes. Actual Lordship, I'll just place Your Lordship, because the enrollment has to be more than 150, Your Lordship.
The provincialization of service or school?
The school was provincialized in the year 2013, Your Lordship.
2000?
2013 under the 2011 Act, Your Lordship. But the third post was left vacant because there was some dispute, Your Lordship, with the respondent number 7. Respondent 7 or 7?
Yes, sir.
With respondent number 7.
The order of provincialization was set aside.
Lordship, whatever may play the fact, Lordship. The school where the petitioner as well as the respondent was 7, they were working, that particular school was provincialized in the year 2013 under the Act of Provincialization Act of 2011. Then agreed by the provincialization order of the respondent number 7, I preferred a writ petition. Then this honorable court remanded back the matter to the authority for reconsideration. Now, during reconsideration, what the district scrutiny committee Lordship found, the the recommendation of the respondent number 7 that was cancelled on 7/1/2015. But when the recommendation in respect of respondent number 7 was cancelled, on the very same day, the director has issued the provincialization order in respect of respondent number 7. The cancellation of the recommendation made by the district scrutiny committee that was not taken into consideration while issuing the order of 7/1/2015. Now, ultimately, I again referred the petition Lordship by challenging the order of provincialization of the respondent number 7. Now, ultimately, on 2019, this honorable court directed the set aside the order of
Then I have understood. Problem is, what they're saying is, it was the case of, 2017 enactment.
My concept.
Now, if it is to be considered, that has already been repealed. Now, if you're at this stage, as per the Act of 2017,
Lordship.
your service cannot be provincialized because it doesn't fulfill the criteria as required under
That
the
is why,
two thousand
Lordship,
seventeen Act.
can it, that Lordship aspect has been considered by this honorable court while Lordship disposed of the earlier writ petition in order dated 18/11/2019. Lordship may kindly come to page 62.
60?
Page 62.
62.
Lordship may kindly be affected portion, page 62, page 64.
Hmm. Ah.
Paragraph 5, this court having gone through the impugn order dated 7/1/15 as well as the minutes of the district scrutiny committee quoted above is also of the view that if the district scrutiny committee had cancelled the earlier resolution of 7/1/2014, that in respect of resolution number 7, it could not be the basis for provincializing the service of the resolution number 7. Now the operative part. 6, accordingly, the present petition is disposed of directing the respondent authorities, more particularly Director of Secondary Education, to review the impugn order dated 7/1/2015. And if the director finds that the district scrutiny committee in their meeting held 7/1/15 had indeed taken the resolution as quoted above, the impugn order dated 7/1/15 also requires to be reviewed and consider provincialization of the petitioner. The director will do the needful as provided under section 24 of the Assam Education Provincialization of Teachers, Reorganization of Education Institution Act 2017, and the aforesaid exercise shall be undertaken in period of 3 months. Now, under section 24, there is a statutorily empowered the director to review its own order, but they have not reviewed the order. Now they have taken an additional plea that my claim is on the basis of humanitarian ground. There is no number of students, there is less number of enrollment. That was not my case, and that was also not considered in the earlier writ proceeding. What the director secondary is directed to reconsider the matter, Lordship, in view of section 24 regarding the order of 7/1/2015. But till that particular provincialization order is not reviewed.
No, if it's not reviewed, how can you file a second writ petition?
No, ultimately, Lordship, in compliance of this order 18/2019, the director has passed this impugn order 20th June 2023, page 65, stating the same ground, page 63.
60?
Page 65, Lordship, type copy. This was done on 20th June 2023. This order, Lordship, is passed by the director in compliance of this order of 28/11/2019. Now, instead of reviewing the order under section 24, Lordship, kindly come to page 66.
You see, order that 18/11, 19.
18/11/2019 was the court's order. Direction is given to the director review each order of 7/1.
Then what about this 23?
By this 2023, the director, Lordship, again, Lordship, cancel the prayer of the Lordship, the petitioner, Lordship, stating the same ground. But here from 2013 itself.
No, I am asking where the March 2020, this is, where is this order?
20th June, Lordship.
Page 65, there is a 18/11 and order dated 20/03/2023. What is this order?
22. Yes, sir.
Clean and fair is the order
Yes,
dated.
sir. 20/3/2023.
20th March. Is there any order of the court?
But there is no such order of 20th of June, March 2023. It is only of 18/11/2019.
But there is a mention of this order.
Mention is there, Lordship, but there is no such order. 20th of June 2023. Now, this order was also Lordship put to challenge. The order of the 20th June 2023. This order was also set aside also subsequently by this honorable court. That Lordship will find at page 69.
See, this section 12 appears to be that their cases shall be reviewed as per the eligibility norms set forth for provincial under this act.
Yes, Your Lord.
If it is reviewed under 24 and which provides that the provincial eligibility norms shall be as per the 2017 Act,
That is Lordship.
and as per the 2017 Act, if you are not eligible,
My
then-
claim was not under this 2017. Act.
see, ultimately court has directed to review
Lordship.
under section 12.
Section
So
24.
24.
24.
Section 24 says the eligibility norm shall be with the
Section 24 is different. Because it is not the case that I was not Lordship recommended. My service also recommended. That recommendation was not cancelled by the authority. Lordship, kindly come to praise the act, Lordship.
recommendation by whom?
By the district scrutiny committee.
Then state.
No, earlier, Lordship, it was the district scrutiny committee's recommendation.
There is no state requirement of state.
No,
become-
Lordship.
Hmm?
But subsequently, my service was recommended in the year 2012 by the district scrutiny committee.
It's okay.
That order was not cancelled.
But then you have not been provincialized.
No, not provincialized because
That's why you have
when
challenged.
I
And
appealed this honorable court,
ultimately this court
directed
to review, right? As per section 24. And section 24 is,
prior to that, Lordship, prior to that, before 2019, Lordship, this is the fifth round of litigation since 2011. While the order
so
of
ultimately it's this 1811. Ultimately 1811 order. Ultimately order to be complied with, or the court has, the ultimate court order would be 1809.
But this
1811.
order is also subsequently I assailed this 23rd of June order. In the subsequent writ petition, this order is also set aside, taking into consideration the contention raised by the writ petitioner. That is why the order was of 20th June 2023. This order was also put to challenge, that page 69.
Then
In this writ petition of 2023, this particular, while the considered the claim made by the petitioner, that was taken into consideration by this honorable court. Ultimately, this order is also set aside.
Then
20th June.
Then
That-
why you are showing this 60? Once it is set aside.
No, why I'm saying this is because although there is a direction to review.
So finally, you have challenged this, right?
Yes, yes.
Then
That
what is the order?
Order that Lordship will find at page. Lordship will see the page of the, while I challenge the order of 20th June, what was the observation of this honorable court, page 70. This was order of 28th July 2023. May I read this order, Lordship? From third paragraph, Lordship, it is page 70, Lordship. The writ petition filed by so-and-so, by the order dated issued by director, whereby earlier order dated 7/1/15 was reviewed in terms of order dated 19 passed by this court in WBC number so-and-so. In WBC number 799/2018 was disposed of on 18/11/2019 with the following direction. Accordingly, the present petition is disposed of, directing the respondent authorities, more particularly DSC, to review its impugn order if the director finds that the district scrutiny committee in their meeting held on so-and-so had indeed taken the resolution as quoted above. The impugn order 7/1/15 also requires to be reviewed and consider provincial. This 7/1/2015 is the provincial order of the respondent number 7. The director will do the needful as provided under section 24, so. The aforesaid exercise shall be undertaken within period of 3 months. Now, a perusal, let's kindly say, this is very important. A perusal of the order dated 26/2023 would indicate that the case of the petitioner was rejected on 2 grounds. That these same grounds have Lordship reiterated now. First one is there is no any clause in the Assam Education Provincialization
Services of Teachers and Reorganization of Educational Act 2017 as amended 2018 for provincialization of service on humanitarian ground. Secondly, the provision of the Act 2017 under Section 319 provides that there shall be an additional post in the same subject of Fencer High School High Madrasa if the minimum students appearing in the last final.
After this, what happened? After
Therefore,
this order.
so ultimately, Lordship, on the consideration, this is important, on a consideration of the
Okay, I have
order.
read that.
So ultimately,
After this order, then
the
within 2 months from the date
yes,
of receipt-
again, Lordship, reiterating the same fact, Lordship, again, this import order is passed 15/3/2024,
where it is.
page 80, same ground.
You come to that, no? That is why you are, then you are challenging this again.
Yes, Lordship, you kindly see the region, page,
Service of selling out is
That's
for
page
the
81.
under the regular.
page 81,
cannot be
Lordship,
considered for-
this ground or this plea has Lordship, this honorable court already negated. Page 81, further, it is also stated that there is no provision of Provincialization Act of 2017 for promotional service of the institution on humanitarian ground. In addition to the above fact, as per respect headmaster, aforesaid school, the number of students on the same grounds, they have reiterated, Lordship, since 2023. Now, the director, the present director also filed affidavit stating the grounds as they have already taken in order at the 2023 and 2024. But this plea has already been, Lordship, set aside by this honorable in earlier proceedings. Here only ground is that there is no number of enrollment, but that was not my case. That was taken into consideration by this honorable court. That is why on 29th January 2026, this honorable court, after hearing going to this order, directed the authorities that since the order of provincialization in respect of number resolution 7 is Lordship set aside. So then you have to take the measures, Lordship, to provincialize the service of the petitioner. That is the order of 29th of June
Now,
2026.
today, if your order has to be passed, I mean, service is to be provincialized,
Lordship.
under what, which law?
So that is why on last occasion I have made a subject, this same query have put to me, Lordship. Then I have submitted that if the authorities, Lordship, desire to provincialize my service under 2017 Act, then I have no grievance, Lordship. That was also, Lordship, and then kindly come to.
Then it's okay, but then problem is that
Under 2017 Act, Lordship.
you read,
That please, Lordship, kindly say order is
you
5/1
read
2000
section 24.
5/1/2026.
Ah.
While the matter has been heard, the same issue, Lordship, arises. Then this honorable could make this order, 5th of January, January 2026. There is order, Lordship, 5/1/2026. May I read, Lordship, that order? The matter has a secured history. The private respondent number 7 has filed 2 writ petition, while the instant writ petitioner has filed 3 writ petition, including the present one. The matter relates to claim for provincialization of service against third assistant teacher, which was kept vacant due to pendency of the court case, as reflected in the post-creation order dated 3/6/13. The respondent number 7 was provincialized against the said post by the order dated 7/1/15. According to the petitioner, despite the recommendation made in his favor by this district scrutiny committee having been cancelled on
Against the
7/1/15.
state post by the order, it's not 2025, it's 2015.
Now, since the respondent 7 has returned, Lordship,
The respondent was permitted against the state post by the order 7/1/2015, not 25.
no, 7/1/2015, Lordship.
Then why it's 225? Is it 2025 or 2015?
Oh, sorry, 15.
It said it's
No, this is
mentioned as 25.
typographical error, Lordship. This should be 7/1/2015, Lordship. Then, Lordship, since the respondent number 7 has retired from service on 37, notice to her was deferred by the order dated 31/5/2024. Mr. Decker, this is important. Mr. Decker, our consumer submit that petitioner does not have any claim against respondent number 7 as on date, and that the petitioner is willing to accept prospective provincialization in the event of writ petitioner is decided in his favor. So, considering the above submission, so and so, so and so. So, on 29th one, this, let's say already I have pointed out that order was issued.
and directed to the authorities what steps they have taken to accommodate my service. Now today Lordship again came up with the same contention.
No, that's why I'm asking. That has not been decided. What I'm asking is, you are entitled under the act,
Lordship.
which has already been repealed,
Yes.
right? Now, today, can your service be provincialized under the repeal act?
Lordship, what happened, Lordship, while the act was Lordship,
Because reason is, if the order has to be passed, you may be granting from the date of provincialization can be granted, but it has to be on the order has to be passed, right?
Lordship,
As per the existing or current
existing act,
enactment act.
Lordship.
Suppose if you're not eligible as per the existing act, how can you be considered? Because you are entitled under that act, which has already been repealed.
Although those are after repealing the act.
Because they will not be empowered.
No, that is all. I'm
The respondent authority will not have any authority to issue any order, pass any order under the non-existence or repeal the act.
When the earlier act of 2011 was repealed on 23rd September 2016, immediately the state authority came up with a review petition. And in the review petition, while disposed of, there is a direction is given the order, which has already been Lordship issued or passed prior to cancellation of this order. The act, Lordship, that 23rd of September 2016, those will have still in force, Lordship. Here it is a case, my service was recommended in 2012 itself. Now, in view of that reviewed order, Lordship, that is still that is not cancelled. My recommendation is still there under the 2012.
I understood, but then today order has to be passed today.
But they have, Lordship.
Under what law?
Lordship, they have.
Which one?
17, but they have come up with a different ground on humanitarian ground and number of students.
Humanitarian
But that
ground
was
is
not my case.
humanitarian ground is different. Second ground is that you are not eligible as per the norms of 2017. That is what they are saying. Humanitarian ground is it's okay.
Kindly see the after 2017.
I am asking, I understand your predicament. What I am asking as an officer of the court, suppose an order has to be passed today under any act. Is it, you may be entitled, can they pass any order under the repealed act?
That cannot be lost.
So that's the
We
difficulty.
have to consider under
Today, you may be entitled under that. Now, the current the enactment act, suppose, I have not looked into it,
Yeah.
I mean, deep inside, but then if the act doesn't permits, suppose under the new current, the existing act, if you are not eligible, for example, just because you are eligible under the repeal act, can the order be passed today? That no, he was eligible in that case, under that act, although it has been repealed, will promotionalize his service under that act. Can it be done? It is unfortunate that because of the litigations and the thing, but then we'll have to go by the law now, isn't it?
under
What is your view on it? Because the provincialization has to be when there is an enactment. It has to be under that act.
Existing act, Lordship.
So in that case,
That is existing act, Lordship, that their only ground is that the number of enrollment. Only they have said, I have also not verified whether the enrollment, Lordship, exactly, Lordship, what they have stated, whether it is right or wrong.
that is
You don't have
important.
any instruction, Lordship.
More
See-
than your merit, you may be entitled. Suppose assuming that you are entitled to be provincialized, but the passage of the time
Lordship. Think of the
may not be your fault,
not
but then the
have the authority.
invocation to invoke the particular provision, we cannot direct them to invoke a provision which has already been repealed, unless there is a saving clause. You find out there must be a saving clause under 2017. You read to the section, you deal with the, I mean, go to the section
This
24
section 24
and the saving clause. And if you say that the division bench,
Lodge.
that may have a relevancy also,
Yes, yes.
right?
Because in review order, Lordship, the order which has already been, Lordship, issued from the department, that was not touched, Lordship. Although, Lordship, the act is struck down, that, Lordship, protection.
But the
was
orders
given.
were,
That protection was given and
the
the
orders were in favor of respondent number 7, not in your favor.
but the recommend that was cancelled. While the act was in force, the provincialization, the recommendation of the respondent 7 was cancelled. But that aspect was not taken into consideration while Lordship issued this 7115 order.
It's okay. I find it, I mean, as simple as you are trying to project. The issue, larger issues are there. Suppose if we find that you are entitled to be provincialized, let us assume you also. Can we direct, because your provincialization would be passed in terms of the act only.
Yes.
Now,
Under the existing.
today we find that you have been deprived under the new, I mean, the repealed act.
Repealed.
Now it has come into force, new act. The order would be passed today, right? Unless there is a saving clause or the order of the court, say as you have just referred, maybe division bench there.
Yes, yes, there. The order.
Have you annexed that? No.
No, you have not annexed.
That's why I'm saying.
So let me.
According to this court, after hearing you and after considering some materials, I find it's something larger issues.
Yes, Lordship.
Merit, I've understood.
Order is there.
Have you understood?
Yes, Lordship.
What I'm trying to indicate.
The review order as well as the saving clause. I will place that order, Lordship, that review order.
Had there been no enactment, right? It's an office circular, office memorandum, whatever circular doesn't have the statutory force, then matter would have been different. Writ court, although enormous power,
yes,
unlimited, but then we cannot pass an order
under repeal,
which is contrary to the
I understand.
act, unless that act is the provision is challenged. Is not it?
True.
So that is the
But
difficulty.
there is a review order, which I will next time I will.
That
place
is the difficulty. You, I mean, all these areas you looked into it.
Yes, yes.
Because this may have a bearing
Yes.
tomorrow.
Because
Simply, we just cannot say. Forget for a time being, forget about your entitlement. I mean, your right and all this thing. In such a circumstances, when you look back, certain orders we have passed, it creates a problem rather. Because we after a while, so human being, we don't foresee most of the time. I mean, it cannot be. So these are appears to be very small, may not be entirely, I mean, much bearing on you. But in a larger interest, I mean, larger perspective.
Definitely, I will come up with that.
So you have no other instruction than this.
Same ground. The same ground since 2020. Lordship.
Heard, Mr.
A record.
Learned counsel for the petitioner. Mr. M.S. D. Musahari, Learned Standing Counsel, Secondary Education, submits that the instruction which she has received is as same as what is projected in the already projected in the is as same as what is already been taken in the affidavit in opposition. Please stop. Next para. As prayed for by the parties, let this matter be listed after 2 weeks.
Not
2 weeks. Should you record that or you just remember that?
I will remember.
Okay.
I know, Lordship, that's then I am like delaying since 2020, Lordship.
Yes.
After 2 weeks, that may be fixed, Lordship.
2 weeks.
Because
Let's give that
after view vacation, Lordship, I need,
3 weeks. Then in that case, 3
after
weeks.
view vacation. No.
Hmm.
Item 24.
In this case, your lordship, the respondents were supposed to file affidavit, Lordship.
Who is the respondent?
Assam Agricultural University, your lordship.
Yes, who is for the standing council?
P. Kotogi sir was there. P. Kotogi sir was there.
P. Kotogi.
P. Kotogi.
Or Mr.
P. Board, the
P.
lordship.
Board, the learned counsel for the further 3 weeks time is granted
Lordship.
to the respondents to file affidavit.
Lordship, can an observation be given? The last time also they took time, Lordship.
Hmm.
Can an observation be given, Lordship?
Saying what?
Regarding the last chance be given to file affidavit.
Let us see. Nobody is there.
Lordship. And then kindly let me fix, Lordship.
Hmm.
After 3 weeks, Lordship.
Give the date.
April. Oblige, your lordship.
Yes.
527.
Item 25.
Hmm.
The petitioners are working as LDA, but they have not received their salaries.
Hmm.
So this is the second round of litigation. In the first round of litigation, this honorable court had directed my lord to scrutinize the records. And in initial order, there was a observation that their services were against sanction post, then a review was preferred. So in the review application, this honorable court had said that if it was not against a sanction post, it has to be scrutinized and a speaking order has to be passed.
Hmm.
So accordingly, an order has been passed. Now, these petitioners, my lord, they are working from 1995. Even today, they are working. And it is in the post of LDA. It is not that their services are required for 2 hours, 3 hours. Now, the government is yet to file an affidavit.
Now, how you have been appointed?
Well, through an appointment letter, even in the sanction post is also there, but the government is yet to file an affidavit.
No, how you are appointed?
Appointed, my lord, regularly, my lord. Appointment letter.
How? Regularly how? Was there any advertisement?
No, my lord, no.
Was there any selection process?
Yes, there was selection process, and according to selection process.
Any advertisement?
Yes, madam. We were also, our service books were also opened, my lord.
I'm asking whether there's an advertisement.
No.
Advertisement,
My lord, in the appointment.
any selection process?
Page
Forget about appointment.
27, lordship will kindly see the appointment order. madam.
We're not concerned about appointment order. That is there. Page 27.
27, madam.
Huh?
Wait.
In pursuant government sanctioning order. What does it mean there? No advertisement,
No,
nothing.
it was, my lord, allotment was given. So pursuant to this,
It cannot be permitted.
no, even, my lord, even for the sake of argument, let us assume that, my lord, yes, the appointment was divorce and advertisement, my lord.
Hmm.
Now, in view of Uma Devi and Jaggu judgment,
Hmm.
if the law, the Supreme Court has laid down the law that yes, the services of a petitioner is required.
Hmm.
Even today, they are rendering their services, and the school is utilizing the services of the petitioners.
Hmm.
So
What is the impugn order?
Impugn order, my lord. Initial order, your lordship will find at page 71, and the operative portion starts from page 75. This order was subsequently reviewed. I will take to your lordship, page 75, last in view of the above. Lordship, got it, my lord?
I'm asking an impugn order.
Yes, my lord. Impugn order is at page, my lord, 26, 121, page 121. Page 121. In last set 122 from down below, my lord, in summary. Lordship, got it, my lord?
Hmm?
Like 122, fourth line from bottom, in summary. Does you
Hmm.
got it, my lord? In summary, the hearing highlighted procedural deficiencies in the appointment process and lack of transparency. The petitioners failed to provide sufficient evidence to support their appointment. It is also pertinent to mention that during the said hearing, it was admitted fact that the petitioners that some appointments were made based on recommendations while some others were appointed in lieu of donations of land, etc. The finding is in view of the facts and circumstances stated above, the claim of the petitioners could not be considered as there is no specific guidelines traced to be followed for appointment of the petitioners, and in absence of specific guidelines, petitioners were appointed without following due procedure of law. Further, no such document are found during the hearing to enable to prove that the petitioners were appointed against sanctioned vacant post. Hence, the claim of the petitioners are hereby rejected. The Lordship will appreciate one aspect of the matter. If there is no sanctioned post, my lord, the schools, there are two schools. In these two schools, the post is of LDA and the services of this LDA is being utilized.
You have been heard? It's a good order?
No, my
No,
lord,
no right.
well, in view of this judgment of the, my lord, this Supreme Court in Uma Devi and Jaggu, my lord, these are procedural irregularities, my lord. So and procedurally, because even the, my lord, respondent number 6 and 7, they have filed an affidavit and it supports my case, my lord. In the affidavit, they have stated that till date, my lord, I am working in that school.
Working is something different. How your initial appointment has been made.
No,
That is
why
more important.
Initial amendment, my lord, at page annexure 1, lordship is in, there is an order, my lord. So if there was no initial appointment following due process of law, my lord, how come this appointment order was issued by the Director of Secondary Education?
That's the whole problem.
So that is why, my lord, in view to overcome this.
You are saying that you have been appointed just like by issuing an appointment order. There is
Yes.
no selection process preceded by any selection process.
Let us, yes,
Nothing, no advertisement, no interview,
yes,
nothing.
so keeping that aside, keeping the, yes, there was.
That we cannot keep it aside. This
No,
is
my
the
lord.
crux. This is
Now,
the
yes,
issue.
now, my lord, let us say that this appointment was an illegal appointment. For 95, a government doesn't know that whether the post of LDA is required to be filled up or not. Whether in a
best-
school,
at
whether in a school, my lord, the
You'll
post.
you'll be paid with the salary or whatever remuneration which you
Yes.
have worked.
Yes, my lord.
That's all.
That is why I am asking, my lord.
Nothing more than that.
That is why, so let them, my lord.
You have
reconsider-
retired already.
Reconsider, my lord, no, we are to retire in September 27, my lord. February 27, my lord. February 27, we are going to retire.
Well, set as that you will not allow it to continue. Since your service has been
Yes, they are utilizing my services.
utilized,
And that
the
service.
period which you have worked
Yes.
will be paid.
And
No
my
more,
lord,
no more
the
service.
service.
Let the post be, if there is a sanction post, let there be an advertisement. That's all.
Yes. Now, in absence of, my lord, a sanction post, how, my lord, the government is not aware
You are not able.
that.
Only were concerned about how you were appointed,
Yes, my lord. This.
In your own showing, on your own submission,
Yes.
by your submission,
Yes, ma'am.
there is no selection
Now, my lord, the
process,
finding
nothing.
of the finding, it
This
says
is
that.
not an irregular appointment, it's an illegal appointment.
No, my lord, if it is an illegal
If
appointment.
it is the illegal appointment, it is incurable. It cannot be cured.
But, my lord, after 25 or 30 years,
Doesn't matter.
whether, my lord, because what is.
Doesn't matter.
No, my lord, in this judgment.
See, your appointment has to be for irregular,
Yes.
not illegal.
Yes. Initially, my lord, they were appointed by annexure 1 and annexure 2.
Sir, that's what I'm saying.
Yes, my lord.
It cannot be permitted.
So, my lord, if it cannot be, let us assume for the sake of argument, it cannot be permitted, my lord. From, my lord, 1995, we are 2026. As on date, the government is not aware that someone is illegally working in a school.
Yes.
If it is not against a vacant post, my submission is, my lord, what I am trying to impress upon your lordship is, my lord, if the services which the petitioners are rendering, it is not against a sanctioned post. Now, till date, the petitioners are working. Does it take more than 20 years for the government to identify that, yes, some intruder has
come to the school and has got hold of the documents.
That's why you will be entitled for salary or whatever remuneration which for the period which you have worked, not more than that.
So let them clarify, my lord.
What
The government
clarify?
is-
It doesn't-
Government
doesn't
is
need-
yet to file an affidavit.
Doesn't require
Hmm?
as clear as noon's day.
Yes, my lord.
Huh? As clear as noon's day, illegal appointment.
No, my lord.
It is not curable.
No, no,
Matter and
my lord,
you are class 4. You are class 4. Group 4.
Working as a gate 4.
That's what I'm saying, grade 4.
Yes, my lord. What happened?
Same school,
No,
various
no.
school. How many schools?
High school.
All.
All are.
all.
Actually, what happened in
One
this
school or
in
various
this
school?
case, my lord,
Different
in the year,
It's all one school or various school.
Different schools.
they are different school working. At that time, in the year 1994, my lord, there is a government policy decision that the director can apply, director can be appointed as a gate for employee. If there is any vacancy post, they can allot it, actually. They can allot the post because the vacancies was there. That is why they have been working. After that, then service book has been open. Then they are working, but they did not get anything, my lord. Then I approached before this honorable court. This honorable court passed an order and find out that these appointments were not illegal, but it is irregular. That is why on basis of Una Devi, my lord.
That finding.
Yes, my lord. Lordship kindly peruse the order passed by this honorable court in the year 2015, lordships.
Page.
It starts from 96, my lord. It's a long judgment, my lord. Passed by this honorable court, my lord. This is not illegal, my lord. They were allotted. The director has been
So as
allotted
that,
because
so as that record.
allotted against the vacant post. Then after this order, my lord, they file review petition, my lord. And review, lordship is
No, as when it says that your appointments are irregular.
irregular,
Not-
yes,
Not
my lord.
illegal.
Okay, মালপে কৰিবা বুলি ভাবি and they also get salary also. Lordship kindly para 3, my lord. The petitioners are grade 4 employee of different high and higher secondary school of Sibsagar district and were appointed on different dates between 1993 to 1995 by the inspector of school Sibsagar districts on ad hoc basis, my lord. Initially for a period of 3 months and their service were extended from time to time. That is page 98 in case number, my lord. Case number 5051 2024. Judgment para 3. Then lordships, it is the case of the petitioner that they were appointed against sanctioned vacant posts so much so that they have also been allowed to open their service book, GPF accounts. They were paid their salaries up to June 1996, my lord. Whereafter no salary were paid to them. This prompted them to approach this court against the non-payment of their salaries. The court disposed of the writ petition by direct the respondent to refer their case before the expert committee to examination. Ultimately, the respondent number 1 filed WT message 16/12/2005 and 17/12/2005 instructed the inspector schools of all the districts to submit their reports before the Joint Secretary, Government of Assam Education Department on the details information about the Gate 3 and Gate 4 employees appointing during 1991-96, showing their respective dates of the appointment and their respective place of posting, the vacancies against which they were appointed, the post creation orders and their retention numbers, whether they were appointed after undergoing due selection process, etc. In the meantime, the Deputy Secretary to the Government of Assam communication dated 18/11/2005 instructed the respondent to fill up the 23 posts of Gate 3 LDA and 145 posts of Gate 4 by the due process of selection among eligible candidates and give the weightage to the experience earned by the working person and also relax the age bar if they were found to be overage. It is also directed during that the due recommendation to be paid to these incumbents regularly as their service had been extracted by the Education Department. A selection committee was thereafter constituted by the respondent 2, comprising of the 4 members. The petitioners duly approached before this selection committee on the date fixed for verification their appointments, which took place during 1991 to 1996. The selection committee in their proceedings dated 21/2/2000 recommended the case of the employee, showing their reports for regularization of their service in view of their long services rendered by each of them. The matter of all the petitioner found also in that report. However, to the dismay of the petitioner, instead of regularization of their services, the respondent number 2, the communication dated 12/9/2009, directed the respondents number 5 to commence the process for recruitment of the Gate 4 staff in the Provincialization High and Higher Secondary School in their districts. Agreed by this, the petitioner filed another writ petition WPC 4749/2012 before this court, which passed the interim order dated 4/10/2012 by the directing that the petitioners should be allowed to continue to their post if they were still working. In the meantime, the Deputy Secretary to the Government of Assam Education Department, by his letter dated 22/8/2023, asked the respondent number 5 to examine the eligibility.
See, madam, is very simple.
Yes, my lord.
In the review petition,
Yes, my lord.
the respondent authorities were to find out, after hearing you, whether they were appointed on the sanction post.
Yes. To
That's
show
why
the
appeal order, it says, no such documents are found during the hearing to enable to prove that this petitioner was appointed against sanctioned vacant post. Once it is found that you have not been appointed
No,
on a sanction post, then matter ends there.
Yes, my lord.
But then if you were found to be appointed on the sanction post, there be another
Yes,
judgment that will follow. So they have found that you have not been appointed on sanction.
My lord, what happened in this case, my lord, in review, there is only one point it is asserted. Others are not. Your lordship kindly peruse the 18
I've read it.
in review
I have read
petition.
it.
Yes, in the circumstances, we repeat the
Directed to
individual.
Find out whether you were appointed in a
Lordship,
sanction.
kindly bear with me a little bit. In the circumstance, we require the individual writ petitioners to make an application before the Secretary of the Government of Assam in the Secondary Education Department.
Madam, I have read it.
Yes, stating in details, no.
Some in substance, you have
Yes,
to approach the
you-
authority and
Before
so that you are appointed on sanction post.
Yes.
And they have to find out whether you are appointed on a
But
sanction post.
that is,
If you are found to be appointed on a sanction post,
Yes, yes.
Umadevi will apply,
Yes.
Umadevi and the other
but they have make a
will apply, otherwise no.
not, yes.
So they have found that you are not appointed, there is nothing,
No, my
no
lord.
documents
That
to
is
show.
correct, my lord, because they make a
That
make
is
a
correct.
mistake.
You read it again. You read yourself.
No, my lord.
Not
They,
for me. You read yourself.
no, they are against the order passed by this honorable court because only the chief secretary will go through it because they have make a committee. Where is that order that they will make a committee? There is no order like that.
What
Also, kindly
committee?
peruse the review petition. There is not like that. Just to say that I review the review petition are partly allowed. That 21. Only to the extent indicated above and the conclusion that there was no dispute that the writ petitioner were appointed against sanctioned vacant post is recalled and substituted by the requirement of this order to make factual verification in respect of the individual. And it is stated that they will, they make a, lordship kindly peruse this,
Where's the committee? Why you are
why
talking about?
committee, they make committee because
Where is the
this honorable court pass an order to appear before the secretary.
Where is
In
the
which
committee?
case, then instead of that, they make a committee, my lord, and they call everybody on the same day. They did not follow the review petition order passed by this honorable court. That is my pair, my lord.
What do you want to say?
It is
What-
stated
what
that,
review
yes,
order
it is
says?
stated that, every petitioner will appear before the secretary, no? Secretary, before the secretary and show the appointment letter, fresh appointment letter, my lord. But instead of that, they make a committee and they call every,
This order is by
Hmm.
the
There is
committee.
no order passed by,
Impugn order is passed by the committee.
yes, my lord. Lordship, can you
I'm
pay?
sorry. Page
Yes,
123. Is the
that
secretary to
is
the comment and-
147 speaking order, Lordship, can you see? They stated that Honorable Gauhati High Court, Ajit Gogoi, report scrutiny committee which was constituted Department of School Education by notification dated
What's the
to verify the appointment procedure of the petitioner in the connection with the instant writ petition. It is committee they make a committee, my lord, but it is not that they will make a committee. This honorable court pass an order to appear before the
See, to
secretary.
find out the thing, whether committee, no committee, up to the authority. There's no bar. And the decision is,
Since the
decision,
review petition,
madam, decision is by the secretary, not by the committee. You just read so and so, also read.
my lord, this honorable court pass an order review only for one point that they will produce before the secretary whether they have been working as sanction post or not. But instead of that, they make a committee and call everybody and
What's the bar?
so and they
What is the bar?
yes,
Deci-
because
Decision,
yes, pass
who
it,
who has taken the decision? Who has passed this impugn order?
the order passed by this honorable court, that secretary,
So,
but secretary has not passed an order, my lord.
secretary has passed an order.
The secretary has been passed an order after making the committee, my lord.
So, what's wrong?
There is a wrong because
No,
this
no.
is against the order passed by this honorable
Sorry,
court.
sorry.
Huh?
They have constituted a committee
To
to find out.
106%. Lordship, kindly peruse the 106.
Ah,
From the records, the secretary shall verify as to what was the number of sanction posts in respect of the post where the individual petitioner were appointed, and also to find out as to whether on the day when the appointments were made, any of the sanction posts, if available, were vacant.
So,
Because since court has passed an order, instead of they have scrutinized our appointment letters, they make a committee
yes.
and call for the everybody, and they have stated that they have scrutinized, but my client stated that they never scrutinized. They just submit the documents before the committee, nothing else. Then they have passed.
Your duty is to submit the scrutiny and whatever consideration by the authority, what manner, how it is been scrutinized, whether through the committee, whatever. But
Lordship,
ultimately, order is decision is passed by the secretary only.
Go back to me. He will have go. Committee is there, 122, no? Lordship, in order to scrutinize the documents submitted by the DSC Assam committee was constituted to the notification. It is not the contempt of the court, my lord.
No, not at all.
Because this
Not at all.
court, no, my lord, this court has passed an order
See,
to
to
scrutinize.
find out
My lord, in this point, I would like to place one decision, my lord. So I need some more time.
No, you please.
Right now, I don't have, my lord.
We'll give you 10 minutes.
No, 10 minutes, I won't be able to, because I have another case in court number 6.
No.
Because
Just because this is court number 15.
No, my lord.
Just because this is court number 15, so you want to give preference to court number 6.
My lord, I have another matter in court number 6.
You are at the midst of hearing. Why should give preference?
No, right now I won't be. Let the matter be listed on Monday then. Gauhati High Court's order is there.
What?
Like that, my lord. If there is, they won't be able to make a committee if there is an order passed by this honorable court. They have to follow that order. So I would like to place before this lawsuits, before your lawsuits.
See, if the court passes
I not fix this matter.
see, if the court passes,
Matter as a part,
if the court passes an order to either to consider a committee,
No, if there is
they'll comply.
No, if there is an
If
order,
they are silent about the committee and the finally order is passed by the authority who has been directed, what's wrong there? Is there any order not to consider committee?
petitioner was not heard, my lord. They make a committee and place before the all the documents, but they never heard. But what is the order
We're
passed by
hearing
this
you.
honorable court?
Now we're hearing you.
My lord. but
Committee might not have heard you. I'll hear you.
that
We're
is-
hearing you now.
That is why the direction was that, my lord, the petitioner will submit a representation. before
Are
the
you submitting that there's a contempt of the court?
No.
Then
What I am trying to impress upon.
are you not challenging the order of the secretary?
Yes, we are challenging.
We,
the
we
order.
have, that is why we have come.
And argue on the legality and validity of the order.
That is perverse on the face of it.
Huh?
This order suffers from perversity because of the fact the direction of this honorable court
Because,
to the secretary that the petitioner can submit in the.
my lord,
representation.
in the speaking order, lordship, it is written like this. In this connection, a report sought from DSC, then Assam. Accordingly, DSC Assam submitted the particulars in respect of the petitioners
What's
who
wrong?
were appointed as a grade 4 and grade 3 post on
What's
other
wrong?
basis. Lordship, in order to scrutinize the documents submitted by DSC Assam committee, and the said committee submitted report before the Secretary School Education Department, wherein it is stated that any government guidelines or advertisement regarding appointment of the particulars has not been allowed. Further, it is not written like this in this review petition. And further, the
How
State
the secretary, how-
committee has not found.
Madam, how the secretary would write like a order of the court?
Further,
He will write in his own way,
further
on his own merit.
the state committee has not found the copies of the sanction of the vacant post.
Yeah.
It is there. It is there in the my lord.
Yes.
But it is there in the appointment letter, my lord. Lordship, kindly peruse the appointment letter.
Sanction by the
found.
government,
Has not found.
pursuant to the sanction of the government.
On basis of that,
See, there are two different things.
yes.
There is a distinction of this sanction of the government for appointment or the sanction first.
My lord, at that time, 94, there is a.
What do you mean by
government-
sanction? What do you mean by sanction post?
Sanction post means vacant post actually, and
Ah.
yes, vacant post, and they have been working, and that
Only-
is why this honorable court pass an order on basis of Uma Devi. Then they have filed review. Review only they give only 1 point. They give, this honorable court pass an order, my lord. They are not.
Yes, madam. That's all. That's all. Anything? Yes, madam.
Our submission is that it should be against the sanction post. And in the speaking order, it has been clearly stated that these petitioners were not appointed against any sanction post, lordship.
See, madam,
Actually, that is-
you have also done a mistake. What you have to find out, constituting committee is no bar. You constitute whatever. But you could have clearly said that instead of saying the no documents you saw, instead of saying that, if you could have found out, whereas that from the appropriate, the authority, the concerned officer or the authority who is appointed or the where the petitioners are working, you could have found out easily whether the post is sanctioned post or not. You didn't say anything. You just said there's no documents to show that it is a sanctioned post, and they are not able to show.
They were not inviting us to appear before the committee, my lord. They were.
No, it's not. What I'm on is, you could have easily found out whether the post is sanctioned or not.
This, in the speaking order, it has been clearly stated that it is not against the sanction.
Read,
post,
read
lordship.
last one. Read it. There's no
Lord-
documents.
Lordship.
My lord, I
In view of the
point out-
facts and circumstances,
there is a
the claimant
difference
could not be.
between-
Find out
considered.
as
There
to
is no
whether on the
specific
day when
guidelines.
the appointment is
My lord,
made
it
by
is
any of the
written that
if
there is
any
no
of the
guidelines
applicant,
as
if
to
the answer is
only
happening.
follow.
You just recorded the order of the court.
Specific guidelines.
It was
Petitioner
not listed, had
appointed
not
without
specific
being
procedure to so and so.
further note that documents. were
Approval
found
from
due
the state
during
employee, sanctioning order numbers were not provided.
Sanction before, hence declaring of the petitioner hereby rejected. Committee itself is illegal, my lord, because this honorable court passed an order to appear before the secretary, my lord. Specifically, it is mentioned before the, review petition, my lord. On basis of that, Uma Devi.
During the hearing, it was noted that the state had not specified the procedure to be followed for appointment of this so. As a result, approval from the state influence sanctioning order numbers actually were not provided. It was also observed that the selection process for approval
Since
based
it
on
is irregular,
induction.
And service has been passed an order to regularize the service on basis of Uma Devi, my lord. Where is go all this, my lord? Just to see the sanction post, whether they were working in sanction post or not. They were working.
here
They are
you-
working, and that.
Madam, just wait. As a result, approval from the state implementation sanctioning order numbers were not provided.
Who
Instead
provides?
of providing, you should have said there's no sanction.
Who will provide, my lord?
Sanctioning number of the
Provide that
post. And then in this
in the view of the
order you come to the, no such documents are found during the hearing to enable to prove that the petitioners.
my lord. They have
Append-
that they.
Madam, can you
Oh, yes.
hold your horses for some time?
I'm sorry, my
Prove
lord.
that the petitioners were appointed against sanction post, vacant post.
Yes.
Just simply saying would not do. You should have a finding that the post in which the petitioners were appointed is whether it's a sanction or not sanction. That you have not, you just simply say that the documents are not found during the hearing. Not necessarily hearing, you could have found it before hearing also.
Lordship,
It is
page
not happily drafted.
page 3 of WPC 4114, Lordship. The
Ah.
second page of the speaking order has been stated that it was also observed that the selection process for appointment was based on personal introductions, indicating a lack of transparency, Lordship.
It's okay, we have understood that.
Lordship, so
See, you have to read the order of the court in the review petition. What court has said, whether in some and substance, you hear them,
Yes.
whether they were appointed in the sanction post or if they're found to be appointed on sanction post, Uma Devi will apply. If not, appropriate orders.
Yes. And my
So
lord.
as per
Sorry.
the tenor of the order,
The power
implemented
grant-
order, doesn't indicate
you
clearly that whether they were appointed, the post
No, Robert.
in which they have been appointed is a sanction post or not. Simply what you are saying is, it has not been provided by the authority that it is, whether it is sanctioned or not. And during the course of hearing, no documents are found as to whether the petitioner appointed in a sanction post or not. Still, you have kept it hanging.
the way of writing may not be proper, but the intention of this speaking order is that
No, we
there's no
cannot gather the intention.
So,
That's why I'm
that is
saying it's a
the intention of this
tenor of the judge, order.
Lordship.
Lordship.
Clear, simple, maybe a long order, as they say,
Yes.
maybe very, very long order, but the main substance is to find out whether sanction post or
Post
not.
or not.
If it
That's-
is sanction post,
Yes, my lord.
Uma Devi.
Yes.
If
my-
not,
Yes.
out. So we find that there's no sanction post.
Yes.
You have not been appointed.
My lord.
You have not been
if
appointed.
Would not have been.
You have not been appointed on the sanction post.
No, my lord.
Therefore, no right
Has
accrues.
not been appointed against sanction post, but I have been.
So as
Have been
So
received
as-
salaries up to 2000.
Madam, so as
Yes, it is written in the first judgment
not first judgment.
that judgment passed by 2015. I were paid up to 2006.
See, you are relying, you want to show that the appointment order in pursuance in the government sanctioning order.
মই আকৌ বেলেগ এটা পঢ়ি আছো নে Yes, sir.
Madam, you could have found out this.
Issuance of the government sanctioning order.
File. 16 11/91, this could have been traced out.
1611, yes, my
It
lord.
appears that
My lord, there is no document and the document does not exist. There is a difference now. Now, the secretary, he has relied upon a report of the committee. Now, the committee might, because it's an official committee, they might have misplaced or the committee.
is there any committee, minutes of the proceedings of the committee?
Because they have.
No, nothing.
Meeting lordship, but it is the committee who usually finds out. It is not a secretary cannot find
Is there any proceedings which will be recorded?
proceedings recorded. Lordship, lordship, I'll verify that lordship from the department. But lordship, but the speaking out is quite clear, lordship.
By the committee, madam. Now, the committee says that.
How many persons are there?
Yes, now committee.
How many petitioners?
তোমার গন্তি করা।
Two petitioners.
Huh?
Two petitioners in item 25.
We are taking up all the matters together.
Yes,
Sir,
my lord, yes.
why you are so selfish?
No, my lord, in 25, my lord.
Actually, what happened, my lord, actually, all these cases, earlier I was appearing, but they are not satisfied. The client has taken back the file. Only one case is with me. It's
Obviously,
okay, I don't mind, but let them file, my lord, in details, how they have make a committee like that, my lord. Because they are still working, my lord.
Set aside the impugn order.
That is correct, that all are not
Or ask them to.
appointed
that in other cases.
legally. When someone is legally appointed.
Ask to obtain instruction as to whether these posts are sanctioned post or not.
Yes,
If that much
because that
instruction
review is
performed,
only on the
they are
point
not
that
performed.
whether they have been working sanction post or not. And it is in letter, appointment letter also showed that in pursuant to the sanction post.
Mr.
Yeah, that's.
Learned counsel for the petitioner in WPC? Petitioners in WPC?
WPC 4114.
And MS
KDB
KDB in petition.
5051 2024.
And rest, who else are there?
Oh, yes, I'm there, maybe. ক'ব নোৱাৰো, তোমালোক কেতিয়া কেছত আছা? Earlier, another one is I'm appearing.
3 read petitions.
Written to high, yes, 3 read petitions. We both are appearing.
Then MSK, KDB for land counsel petitioner in WPC 5039 and 5051 2024. Huh? After perusal of the impugn order dated what is the order?
Order dated, my lord, page 1.
Date of order?
Speaking order, lordship. 121.
Page.
Madam, I am asking the date of order.
Date.
0106/2020.
1624.
1/6/2024.
0106/2024.
ধৰিব
Past
নোৱাৰি,
Friday.
দিছে নহয়।
Secretary to the government of Assam.
এইখিনি কোনটো কেছত আছে?
Department of School Education,
Oh, yes, Srivendra.
comma,
সেইকেইটা মানে
It is not clear
hearing হ'ল। হ'ব
as
একো
to
নাই।
whether
এইবোৰ কেছ ময়ে কৰা।
the
15th.
in which the petitioners were appointed
আছে। কাহা নাই।
as grade 3 and grade post in the various schools are a sanctioned post is required to be determined
মইতো
by the order of this court.
তোমাক কোর্টে দিব। Elect committee গঠন কৰিব।
Considering above, in view of above, MS
And because secondary education.
Gorua Land Standing Council Secondary.
Second.
This is school education. Same,
Lordship.
secondary.
Appearing for respondent number 6 and 7 in item number 25.
Who is responsible?
CC,
And
headmaster.
to obtain
Principal.
instruction as to whether the post in which the petitioners were appointed are sanction forced, irrespective of whether the appointment were made the holds the rules. Yes. Mr. Swen, can you find out whether the post or sanction post or not?
We'll try, but because I'm the principal who recently I have appointed. The principal was I have posted recently, Your Lordship. But still we'll try to find out if anything comes.
This poster already been vacated, they are working in
Let
vacant
them
post.
do some exercise.
My lord, in the affidavit which has been filed by the school authorities, in para 16, they have written that it was a sanctioned post. The affidavit which has been filed by the principal and
They are the one who have appointed you.
no, that is, no, they have written it, my lord, that it was petitioner number was appointed against a sanction in favor of the school.
No,
When do you want?
So that
Lordship, after 3 weeks, Lordship.
3 weeks.
Lordship,
No,
sometime
it-
Before, before.
Lordship, before.
Someone is going to retire, my lord, because they are working since 94, my
Lordship, we
lord.
have to verify each and every petitioner individually whether they were.
No, বেছি নাই নহয়, কেইটামানহে আছে। যিকেইটা আছে, সেইকেইটা confined to this.
2 weeks. 2 weeks, can you?
Lordship,
Yes, why not, my lord? They can.
it'll be difficult,
No,
Lordship.
no, it's not you who is going to do it.
Difficult, Lordship, to find out, Lordship.
Why you can say that, why not?
পাৰিব লাগিব।
God. Lordship,
Before Bihu,
Lordship, after Bihu, Lordship.
again,
After
everybody wants 3 weeks, 3 weeks.
3 weeks.
Then let me be fixed. এই হেৰি ভাইটি, এটা date দি দিয়া। 24
my lord.
24 মাইলত
How many petitioners?
only মাইলত 4, 5 like that.
ইয়াতে two, আপনার
মোৰ তাত 3টা 5টা আৰু এটা 6টা 6 petitions are there.
Why you
Let them file before Bihu because
Why
only
you-
6 petitioners are
Madam,
there.
why you are not trying to give a effective reply when we ask something?
Total 134 and get 4 is
I ask you,
no, my
how many-
client. I am thinking about my client, my lord, actually.
Yes.
কিছুমান অহা নাই, কিছুমান আহিছে।
next.
Oblige your lordship.
Try you impress upon the secretary. Find out. We cannot decide like this. Or else we will have to again allow the writ petition unnecessary. We know that they are illegal appointees. We are not inclined to give them a relief.
Irregular, my lord, not illegal. Irregular.
What irregular?
Irregular, my lord.
It's
Against
No. just because there is sanction.
appointment. Actually.
No. Just because there is a sanction for you just cannot be picked up and
No, there
appoint.
is a
That is what
there is a-
what more illegal than this.
no. At that time there is a policy decision. Actually, in the year 1994. my
Okay,
lord.
thank you. Next.
oblige.
Lordship, I'm appearing on behalf of Counsel Mr. S. Thakur.
Huh?
I'm appearing on behalf of Counsel Mr. S. Thakur. Lordship, affidavit is yet to be filed.
What is the matter?
There are certain vacancies, Lordship. For the subject Persian and Arabic, no recruitment, no advertisement was issued, Lordship. Lordship will find it out for particularly why these 2 subjects were left out, Lordship. Lordship, sometime may be granted, Lordship.
Lordship may let them file their affidavit in 2 matters. In 2 matters they have filed, but other 2 is yet to be filed, Your Lordship.
It's a similar matter. What?
4 matters are similar. In 2 of them, affidavits have been filed.
It will cover. If it's a similar matter,
Affidavit will be required, Your Lord.
what is this issue?
Lordship, regarding
Persian, graduate in Persian and B.Ed degree.
Arabic and Persian, Your Lordship.
Student in
Graduate
Persian,
teacher.
beginning
an advertisement was released, Lordship. Persian and Arabic was not there, even when the vacant posts are there, Your Lordship. That's the case.
number of percent. Yes, madam, what is your stand? You cannot compel them to fill up. Law is very clear.
No, we cannot compel them, but our case is that there's vacant post, your lordship.
Doesn't matter. Vacant doesn't matter.
Come to WPC 5855 2024 lordship. In that matter, we have filed an affidavit lordship.
Saying what?
Lordship, that
Page, item
lordship, item number will be lordship,
5852.
last item, 31 lordship.
5855.
5855 lordship.
Give the affidavit.
Lordship,
Your simple prayer to include the Persian subjects in the
Lordship,
advertisement.
I understand, but lordship, I'm not in a position to argue this matter. I'm not in this matter.
You argue whatever is there.
I'm not in this matter. My name is not there, your lordship.
May affidavit by the respondent number 2. Ha.
respondent number 2 lordship, page number 62 lordship. In the advertisement itself, there was a clause lordship that vacancies may vary due to administrative reasons lordship. The Director of Secondary Education Assam reserves the right to make changes in sequence of the recruitment process after publication of the advertisement. In the very advertisement, this clause was inserted lordship, and lordship, due to rationalization process lordship, the actual assessment of requirement of postgraduate teachers in Persian may be made lordship. The actual requirement will be lordship considered after rationalization lordship. There is a shortfall of graduate teachers lordship.
The advertisement is for writ petitions are challenging the, I mean, in respect of the advertisement, same advertisement, same,
Lordship.
one advertisement.
Yes, lordship. The one, lordship will find at page.
Which advertisement?
Advertisement dated, your lordship, this one. And dated 26/12/2023, your lordship.
Page?
Lordship, you are in,
Item 35.
I am taking the item number 28, your lordship.
Find out.
Same advertisement, same advertisement. Lordship, may kindly come to para 9 of my writ petition, your lordship.
Page number 15.
15.
Any interim order is there?
No lordship.
No, no.
It's not over yet. No. Have you, has been completed the selection process?
Selection process lordship. It is still, there is still vacancy lordship. Lordship, I'll find the up-to-date status lordship in this matter lordship.
No. Disposed of.
Lordship,
Disposed of. Writ petition disposed, all disposed of. See, they said that for the subject, Persian subject, rationalization is going on. As and when it is completed, it will be filled up.
lordship, my humble submission.
And you being a graduate,
Postgraduate teacher. Lordship,
postgraduate, you are eligible to participate in these posts which has been already advertised.
lordship,
See, reason is very simple. We cannot compel the authorities to fill up this post, fill up that post.
Lordship, my only
You simply says that there are vacant post lying in respect of Persian subjects, right? It has not been advertised, therefore it should be included in the it should advertise.
Lordship,
Is
yeah.
in other words, you want that the post of Persian postgraduate, I mean, what do we call it?
Lordship, what?
The post of teacher,
Graduate teacher.
teacher in Persian subject has to be filled up. That is
No,
what
Lordship,
that we cannot say. We cannot direct.
Lordship, my only humble submission.
They are fair enough. Their rationalization is
Lordship,
going on. They admit that you are the Persian, I mean, the teachers in Persian subject is required, but its rationalization is going on.
Lordship, my only humble submission is, Lordship, I am not in this matter. So I cannot argue on behalf of my petitioner.
Then
because
why you are not appearing? Why you are appearing?
No, that's why I'm saying, Lordship. Mr.
Who are you?
Counsel Mr. S. Bothakul is this matter, Your Lordship.
Where it is? Where he is?
He's not present here today, Lordship. That's why I'm saying, Lordship, may take it up on Monday. If Lordship wishes, Lordship can dispose it off on Monday, Your Lordship. Let Lordship give us an opportunity to put forward our argument, Your Lordship.
Then why
he will argue this matter on Monday, Your
why
Lordship.
you have made a submission
No, Lordship.
on merit?
I was just pointing out that, Lordship.
Nothing will change.
Lordship may take it up on Monday, Your Lordship, for final disposal if Lordship.
I'll record your submission.
No, I'm not. Lordship, but give us an opportunity. Counsel Mr. S. Bothakul will appear and he will place his arguments, Your Lordship. Monday, Lordship.
Okay. On the prayer of Mr.
P. Khatoniar.
Learned Counsel for the petition. Learned Counsel. You are not in this.
No, I'm not in this matter. So that's what I'm saying.
Appearing on behalf of Mr. S. Bothakul. Learned Counsel for the petitioners. I think this is 28 to 31. Common order. Submits that Mr. S. Bothakul has some personal difficulty today. Therefore, prays for listing of the matter on Monday, 23rd. It is made clear that the matters would be taken up for final disposal.
So Monday on Monday.
Monday, huh?
Much obliged.
In the meantime, you find out what happened to the advertisement, whether it's been completed or not.
May it please, Lordship.
Yes.
Lordship, as far alia order dated, opposite party are not filed affidavit.
Yes.
Time may be allowed to file our affidavit.
What is the matter?
Matter about provincialization. Provincialization.
Or MS so learned counsel for the petitioner. On the prayer of MS
And Fukan Manning.
and Foucault learned standing counsel elementary education. Further 3 weeks time is granted to file affidavit.
My lord, kindly date be fixed.
3 weeks. Let them file first.
Item 39.
Yes, respondents are supposed to file affidavit, Lordship.
Yes.
So we have not obtained our instructions yet, Your Lordship.
Further 3 weeks time is granted to MD. D. Musari, MSD Musari to file affidavit in the position. Mr. P. Bordolo, learned counsel for the petitioner is present. Yes.
Also, can you get me fixed? 27 April.
Let them file.
Obligation.
Let them file.
Lordship. Oblige, Your Lordship.
Item 40.
In this
Yes, covered by this judgment.
In this case, Lordship, we have sent a file to the Finance Department, and Finance Department has advised us to put creation of a two post Lordship in respect of those petitioners Lordship, but some clarification is requiring.
No, whether this judgment is this order of this court, that is 05/2024 in Ahmad Ali Sheikh is covered.
So already Lordship, the benefit is going to be given Lordship to the petitioners, but two clarification has been sought for by the Finance Department to.
Who is for the respondent? Petitioner, sorry.
Petitioner को का नाम है डिम्पी petitioner को कौन है देखो 40 LR Majumdar. Lordship, another 2 weeks time may be granted that all clarification would be submitted to the Finance Department.
Is seeking provincialization.
Yes, Lordship. Yes, Lordship.
Then you're going to give them. I'm going to provincialize them.
That in this case, Lordship, provincialization has been approved by the highest level of authority from the Education Department. But it is the file is routed to the Finance Department for the financial approval. That two clarification has been sought for by the Finance Department. That we are submitting that. That's why Lordship, I am praying for another 2 to 3 weeks time may be granted, so that in the meantime that process can be completed.
Ranjit Kumar Das.
So Lordship may dispose the case by directing the department to complete the process within a period of 2 months.
I think that would be better. Because you have, as per the direction of this court, you have also said that it has been recommended. Yes, now appears for the petitioner on call. Mr. P.P. Datta, Learned Standing Counsel, Secondary Education for the respondent is. No. Heard Mr. P.P. Datta, Learned Standing Counsel for Secondary Education for respondent, state respondents. Next para. The petitioners has filed this writ petition seeking a direction to the respondent authorities to provincialize the service of the petitioner in terms of the what is that act? In terms of so and so act, we'll give the 2017 act,
Assam Education Provincialization.
Assam Education, something like that. You just provide this. Next para. The petitioner was appointed as assistant teacher in Ashwini Kumar High School, Kachar, in the district of Kachar by the managing committee of the school on 02/07/2010 list of In terms of the next para, huh? Act of 2017, huh? The headmaster of Ashwini Kumar High School prepared a list of teachers with enrollment for 3 years, economic qualification and experiences, etc. of the school, staff of the school, wherein the name of the petitioner was also mentioned. List of, accordingly, the District Scrutiny Committee of Kachar District, after verification of the records, has also has recommended for provincialization of the services of the staff of the said school, including the petitioner. List of thereafter, the state level scrutiny committee has prepared the final list for provincialization of the teachers of provincialization of the services of the teachers of Ashwini Kumar said school, in which the name of the petitioner has wrongly been excluded. List of being agreed, the petitioner approached this court by way of writ petition being WPC being WPC 4382 of 2022. List of this court by an order dated 25/07/2022 dispose of the writ petition with the direction to file an appeal before the appropriate authority in terms of the provisions of Act of 2017. List of on the appeal of the petitioner. Next para. On the appeal of the petitioner as directed by this court, comma, the secretary to the director. What is this? The secretary to the government of Assam, Department of School Education, by an order dated 31/08/2023. Has held that the petitioner has held that the provincialization of the service of the petitioner shall be processed on receipt of the required report oblique proposal from the Director of School Education, Assam. Then what happened?
The last order. We have we have placed instruction that file has been moved to the finance department and their viewer awaited. And also we have submitted that approval of the competent authority, and the Honorable Chief Minister also endorsed his approval. So matter is for clearance from the finance department only.
Finally, the
After approval of the competent authority, matter is endorsed to finance department.
matter relates to, finally, the case of the petitioner has been considered for provincialization of his service, which is yet to be which is yet to be completed. Mr. P.P. Datta, Learned Standing Council, submits that since the petitioner is entitled to be, since the service of the petition, since the petitioner is found to be entitled for promotional of his service, matter has been recommended to his case has been recommended to the competent authority after the approval of the what highest authority, what do you say?
Chief Minister.
Huh?
Even
You
Chief
require Chief
Minister.
Minister.
Yes, it had been, that approval has been obtained, Lordship. For
Approval of the
creation of two posts, Lordship.
highest authority of the, huh?
Yes.
Highest political authority of the state.
Executive authority.
Huh?
He is the highest executive authority.
Political or highest executive?
He is the executive.
Highest executive authority of the state.
For creation of post.
Huh?
For creation of post, Lordship.
For creation of post. Please, the matter is under consideration before the
Finance department.
finance departments, which would be, which may take some time. Please, therefore, he submits that the case of the petitioner would be considered and appropriate order would be passed on according on according clearance from the finance department. List of next para. Having considered that the case of the petitioner for provincialization, no, grievance of the petitioner for provincialization of his service has been already processed. Processed and the petition process, which is currently pending before the finance department. After completion of all the required formalities, I deem it appropriate to dispose of this petition with the hope and trust that the case of the petitioner shall be, the process for provincialization of the petitioner, the service of the petitioner shall be completed as expeditiously by the respondent authorities. Accordingly, writ petition extend dispose of with the above observation. That's all.
May it please, Lordship. Lordship, as per alia order dated, opposite party are not filed the affidavit.
As a further 3 weeks, I mean, under file affidavit. Otherwise,
Further 3 weeks time is granted to file affidavit No, on the prayer of Mr.
As we are.
SBI, London Standing Council. Higher Education, for that 3 weeks time is granted to file affidavit of opposition. MS
P dash.
B dash London Council for the petition is present. Petitioner is present. Madam, you may go there. You may go and do that. No, you may go and type that. You may say, as soon as. Because it will take time. No? You have to finish it today. You may go, no? Ask someone to be. Yes.
May it please your lordship, we have received instruction for the 2 weeks time may be granted to file our affidavit.
Okay. Her MS so London Council for the petitioner, Miss MS N. Chaudhary, London Council, Standing Council, BTC, submits that she may be, she has received the instruction and therefore phrased for 2 weeks time to file affidavit in opposition.
Fixed, my lord.
How?
A date may be fixed because our result has been declared, my lord, by BTC. Only prayer is.
Prayers allowed, let this matter be listed after 2 weeks. 2 weeks.
So, lordship.
2 weeks or 3 weeks?
Lordship, after due vacation, any date.
3 weeks, huh?
3 weeks.
On, huh? Give that it.
Obliged, lordship.
Obliged.
My lord, in this case, I have challenged the order passed by the Education Tribunal and LCR has been received. My lord,
Education Tribunal.
yes, my lord, as per
Yes.
this honorable court, matter relates to provincialization of service of the petitioner against the private respondent.
Yes.
Then, my lord, in earlier 2 round of litigation, first round of litigation directed the matter to be considered by the authorities.
It's okay.
And in the,
What do you want, Sharma Sahab?
my lord, only one issue may be considered, my lord. Whether when the Education Tribunal considered.
Affidavit has been filed.
Here we have not filed our affidavit.
Who has to file? Affidavit would be required or not?
Private respondent has filed, my lord. Here, administrative tribunal has dismissed the petition of the plaintiff, my lord.
That's why he is before us.
Yes.
So,
And regarding here, my lord, record is required, my lord.
Record has
to-
been produced.
Yes.
The LCR has been received. Only difficulty is I am going to read
prove
here.
the genuinity
I am
of
going
the
to read
facts,
the
my lord.
31st of March,
of what?
this month. my lord. And
Since your service is not been regularized,
yes, ma'am.
I mean provincialized, with the question of retirement, are you still
Retirement.
working?
No, my lord, I will attain the age of superannuation.
Don't say that retire.
Yes, mother.
You may
And-
attain the age of,
Superannuation. On your lordship may appreciate whether the government pleader can represent the government of Assam, Education Department, Secretary, Finance Department, School Managing Committee, Headmaster, as well as the my opponent,
no,
private respondent.
no.
This is the only.
That will be a conflict of interest.
Yes, my lord. This is the only ground of challenge, my lord.
Ah.
Apart from entering into the merit of the case regarding date of joining, date of provincialization, etc., etc.
So in the tribunal,
Tribunal, my lord, tribunal has heard in law in
allowing to appear,
all allowing the government pleader to represent all the respondents, my lord, defendants. If that cannot be done,
yes, what is your view?
Provincialization of the respondent
That will
number
come
8
later.
as a seniority, sir, my lord.
Ah.
And here, my lord, in the order itself, it is reflected, page 99. For respondents, advocate Miss Rupa Sonowal, assistant GP. But my lord, on the other hand, my lord, in the
Heard Mr. N. Sharma, and counsel for the petitioner, and Mr. U. Sharma, London Standing Council,
for respondent number 1, 2, and 3, my lord.
respondent 1, 2, and 3, and
And headmaster. He is the for headmaster and private respondent. Private respondent also there? Yes.
correspondent. Name? Your good name, please. Huh?
Our Paul.
R. Paul. Paul Young. Young Paul. For respondent number? Don't appear for both. Private respondent and the headmaster.
Eight is
Is
there.
there a collision? Is there a collision between 6 and 7?
6 and 7 managing committee and headmaster, they can appear, but 8 is different.
It is different.
Okay. As your? Oh, okay. Why you're keeping quiet? Just give their name. As agreed to by London Council for the parties, list this matter after 3 weeks.
No, my lord. Next week, my lord, any date, my lord.
Next week.
If before 31st March, only your lordship may examine whether this tribunal's order is.
If we hear, we'll examine everything, not under your dictation.
My lord, that pass over for that day, my lord, only.
Next week, after a week, we'll see.
Next week, any date, my lord. I will try, my lord.
After a week.
Only that aspect may be considered, whether government leader can represent all the defendants.
We'll consider each and every aspect.
Next week, my lord, any date.
Yes, next week.
No, next week. Yes.
Yes, next. Array, 64. Yes, what is this?
My lord, this matter relates to, my lord, I am a regularly appointed principal, my lord. And after my lord appointment, some allegations were raised against me regarding non-submission of audit report. Accordingly, I was placed under suspension for non-submission of audit report. Accordingly, I have submitted the audit report, and there is no allegation against me regarding corruption, regarding embezzlement of fund. Ultimately, I was reinstated in service, and thereafter, my lord, the inspector held that there are some procedural lapses, though there are no major irregularities of financial mismanagement. Accordingly, I was reinstated in service, and departmental proceeding drawn against me was also closed. But as per order, my lord, page 34B, minor penalty of censure has been imposed upon me, holding that I am not entitled for any remaining salary for the period of suspension, and my increment for 1 year has also been not granted. In the meantime, my lord, my academic charge has also been taken away. My financial power has also been taken away. This creates, my lord, humiliation to me, though there are no major allegation against me. They have filed a affidavit. I have filed reply also.
Still you are working.
Yes, my lord. As a
Then-
principal, regular principal, without any charge, my lord.
With
No,
question of, non-payment of increment.
not payment of increment, non-payment of arrear salary for the subsistence period, as well as financial power, my lord, DDO. DDO academic charge also taken away, my lord. Though there are no any major irregularities against me.
No, major irregular, that's why there was censure.
Therefore, I have challenged the censor, my lord.
Okay. No, you have not been completely exonerated.
My lord, there is no
Fully exonerated, not exonerated. If there is fine, so minor, what do you call it?
my lord, you lordship.
Administrative inability. Certain
My lord,
things
that
are
is also
there.
not correct, because I have annexed the document during my.
See, if the censure is imposed, any increments and all these entitlements are curtailed.
Yes, my lord, that has been curtailed.
Is it curtailed?
Yes, my lord.
Once the censure is imposed.
My lord, censor has been imposed. In the order of censor, my lord, it is stated that whatever I have received, that is my entitlement.
That's all.
But regarding my arrear salary for the suspension period, increment, that has to be paid to me, my lord. And
They have regularized your suspension period.
for the pensionary benefit,
Hmm.
not for any other purpose.
It's up to
And
them. They
censor-
can do it.
My lord, I am also entitled.
You should be happy.
No, my lord. I should be entitled to academic charge as well as that has also been taken away for For not, there are no major irregularities against me. Though they have
But
stated
there's
that
certain irregularities.
administrative inability, I was the principal of
It's
2000
a good ground for to impose censure.
because during my tenure,
Administrative inability.
during my tenure as a principal, my school has secured first position within the district. This is, I have annexed the document.
Maybe,
Yes, ma'am.
maybe, but this is a administrative inability.
Well, there is no clarification, my lord. What in administrative inability, my lord?
Okay,
This is
heard
an-
Mr. N. Sharma.
Yes.
Learned counsel for the petition and MS D. Musahari, learned standing counsel, secondary education, pleadings are complete. Admit,
No.
list for hearing,
No, my lord. For admission hearing, any date, my lord. For admission hearing, any date, my lord.
I'm not inclined actually.
Not for major hearing, my lord.
Pleadings are complete, huh? As I agreed to well, let's counsel for a list this matter after 3 weeks.
2 weeks, my lord.
Not possible.
If possible, or 2 weeks.
3 weeks, not possible.
Obliged, your lord.
Hmm. Forty-five. Yes.
May I please, your lordship? The client has been taken back the file from us. We are no longer in this case.
Issue a notice. Yes, what to do?
Client file to lower.
It is submitted by MS
Okay, Devi.
K. Devi, learned counsel for the petitioner. Learned counsel for the petitioner
On behalf of KDB. Yes, Lord.
that the petitioner, the brief has already been taken away by the petitioner. Therefore, they are no longer representing the petitioner. Considering above, let this matter be listed after 3 weeks.
I'm appearing for the respondent number 9, Lordship.
So, record your name.
I'm appearing for respondent 1 to 3.
No, then you write the submission. MS Udas.
P does.
He does, learned standing counsel. Huh? Then you write that, considering your session, huh? Considering above, let this matter be listed after 3 weeks, huh? Yes.
Lordship, this matter may be taken up after 10 days, Lordship, because
Why?
on last occasion, Lordship, the Assam Public Service Commission was directed to submit that some select list, Lordship, merit list, was pertaining to 2008, but we could not trace out those
2008.
2008 select list. We could not trace out, Lordship.
Why is pending?
No, that the matter, it petition is of 2000, the review petition is filed, Lordship.
This review petition.
This review petition.
Okay. Mr.
B. Datta.
Or Mr. B. Datta, learned counsel for the, U Datta, B Datta.
On behalf of U. Datta.
B Datta, learned counsel appearing on behalf of Mr. U Datta. As spread for by Mr. P.P. Datta.
Standing Council APSC, Lordship.
Then standing on APSC, 10 days. And no, let this matter be listed after 10 days. So as to enable Mr. Datta to obtain instruction. Yes, let's stop this.
May I please, Lordship?
Mm.
Service is completed, Lordship. Matter may be fixed for admission.
Heard Mr. So-and-so, service is complete.
Obliged.
List for admission after 3 weeks.
Obliged.
Lordship, in this matter, service is incomplete. I may be allowed to serve notice to Dusty, Lordship, on respondent numbers 4 and 5.
Heard Mr. MS so-and-so, learned counsel for respondent number 5 and 6?
4 and 5, Lordship.
4 and 5, huh? order of Luxembourg Court dated 18/03/2026 indicates that service report in respect of respondent number 4 and 5 could not be affected. No, service in respect of respondent number 4 and could not be affected. List of next para, MS so and so, non counsel for petition of press for and granted a week's time to take press steps for service of notice upon respondent 4 and 5 by dusty mode as well as usual process. This is the matter after 2 weeks. You take a step within 1 week.
Lordship, and there is an interim order. Kindly
Keep order process, let's continue. Yes.
oblige, Lordship.
Lordship.
What problem?
Lordship, in this matter, the state has not filed their counter lordship.
May it be pleases you, Lordship.
Hmm.
Kindly grant us 3 weeks' time to file the affidavit.
Who has sent this letter to Assistant Registrar Gauhati High Court?
Lordship, probably this was sent by the principal lordship.
Why? How it is sent? Is it
Your-
permissible?
Your Lordship, I'm appearing on behalf of Mr. B. Sharma, the standing counsel for AG. Lordship, the petitioner is a retired provincial school teacher. He filed a petition seeking directions for payment of PPRO. Yeah. Your
Have you
Lordship,
filed the affidavit?
No, Your Lordship.
Your
File
Lordship,
it.
the
Let them file affidavit, lordship.
Heard Mr. So and so?
As Sutradhar, lordship.
Huh?
As Sutradhar.
Learned counsel for the petitioner. On the prayer of learned counsel for the respondents headed by Mr. M.S.P.P. Das, learned distinct counsel so and so. Further 3 weeks guidance granted to file affidavit.
And be clear. You could file affidavit that brings to the record.
because we don't have any more in this regard.
Happen.
Lordship, I am appearing on behalf of SP Shorty.
What is to be done today? Why this has been listed?
Lordship, government is to file the affidavit. Respondent side is to file the affidavit.
They have filed the affidavit.
No.
They have not. You have filed the amended cause title. Have you filed it?
It's not on record.
Sir, yes. Lordship, yes.
Have you filed the amended cause title?
Respondent click করেছে এমএনএস ওয়েবসাইটে ফাইল করেন আমার
Lordship, can it be fixed on another date?
On MS so learned counsel for the petitioner. In view of the order of Luxembourg Court that is 17/03/2026. Comma. And sorry, huh? In view of the order of the Luxembourg Court dated 17/3/2026, comma. Appropriate order request to be passed considering the conduct of the petitioner, conduct of the learned counsel with the petitioner. Mr. Hauba, are you getting what word I'm
Yes,
dictating?
Decimal number 8 has been impleted. And we have submitted the cost title also.
Have you seen the order of the,
No, subsequent to that, it has been done.
that's what I'm saying.
Yes.
I've said, in view of the order of the Lauzima court, that is 1703/2026, an appropriate consideration and order needs to be, request
No,
to
no,
be
it has
passed,
already been done, Lordship.
passed, considering the conduct as reflected in the said order, conduct of the learned counsel by the petitioner in the said order.
It has
Mr.
already been-
Hauba,
yes.
Mr. So-and-so learned counsel for the petitioner fresh for it is granted 2 weeks' time
No, Lordship, it has already been done.
to
We have submitted the cost title, accordingly we have served a copy to the council for the other side.
why you're disturbing in between? Just wait. To take appropriate actions, to take appropriate steps, less after 2 weeks.
I can understand, Lordship.
Have you seen the order of the
Yes, yes,
Lauzima?
I know that order, Lordship.
Therefore,
After the Lauzima order.
This has been listed to take
Exactly, Lordship.
for
After that
decision,
order was
appropriate
executed-
decision.
Exactly, Lordship. After that order.
Therefore, I am granting you 2 weeks' time.
No, no.
Think about it.
Can-
Please,
can-
thank you. Next.
Lordship, kindly hear for a moment.
No,
Lordship.
not at all.
On 17, the Lauzima court passed an order.
You
on the
make
sa-
your submission on next day. We're
On the same
considering.
date, we have taken steps and accordingly we have served copy to the council for the other side.
That has been recorded.
Yes.
Have you seen that order of the Lauzima court?
Exactly, Lordship. I know that order.
Huh?
I have seen that order.
Then,
And accordingly, we have done whatever is required to be done.
see,
We have-
thereafter only this has been filed. This has been, observed, this has been recorded.
After that.
If you don't have seen it, proceed. That's why we're granting you time.
And
Huh?
accordingly, we have taken.
Which order?
Lordship, subsequent to that.
Which order?
The Lauzima court, the order passed by the.
There's so many Lauzima courts order. Which
last-
order?
The last order.
Which is the last order?
On 11th of March.
17.
17th of March.
Huh?
17th of March.
You have already filed.
Yes, we
That
have
has
filed.
been recorded.
Yes, we have filed and accordingly served a
That
copy.
your conduct has been recorded, reflected. And this is listed for appropriate orders today. So that's why I'm granting you time.
My lord, this is a contempt petition, my lord.
Complied?
In progress, Lordship.
Huh? Progress, we are not concerned. Have you complied or not?
So the direction was to consider representation and thereafter regular.
You have considered.
Lordship, we have considered.
BTC authority has decided to regularize the present contempt petition at par with the other similar. Hence, you are requested to submit a detailed proposal and for regulation of service as assistant teacher in any vacant point. As and when the British approved financial, they said a proposal, the present petition will be regularized according to that. This is the approval of the yes, to the
Director, Your Lordship.
education. Director Education BTC. They have decided to regularize your service.
Yes, my lord, but we are not aware, my lord.
Not Mr.
DK Roy.
DK Roy, learned counsel for the petitioner.
And
Mr.
N.R. Sharma, Lordship.
N.R. Sharma, learned standing counsel, BTC, by placing the copy of the placing the communication dated 17/03/2026. From the Secretary BTC, Conclusion, submits that the BTC authority has decided to regularize the service of the petitioner at par with the other similarly situated teachers, subject to availability of post. Thereby, request has been made to the Director of Education BTC to submit detailed proposal for regulation of the petitioner as assistant teacher in any vacant post. This stuff. Considering above, I'm of the view that the order of this court that is 0602/2024 passed in WPC 5783 of 2023 has been complied with. Accordingly, contempt petition stands closed. The copy of,
52 and 53 are similar as well.
copy of the order so and so is kept on record. 51, 52.
Gotcha, 3. 413, 414, and 415.
All. 51, 52, 53. Same. Okay. Then 54. 54 also.
51, 52, and 3.
Three contempt. Same order.
Nice.
Their direction was to consider. They have
Yes.
decided to regularize.
Yes, but my lord, till then.
Very well.
May I legal lordship, as per an office not lordship or service is not completed lordship.
Await service report. MS so and so, land council is present. Yes, list after 3 weeks. Condonation,
May please your lordship.
condonation.
Yes, my lord.
We should notice.
My lord.
Heard Mr.
SP Das.
SP Das, London Council for the,
What I state,
huh?
the state has filed a review petition, my lord.
No, London, you are, then,
My lord,
London,
SP Das, my lord.
SP Das is what?
My standing council,
SP Das, London Standing Council,
skill, employment and entrepreneurship department.
in short,
In short, my seat, SWD seat.
skill,
Skill, employment and entrepreneurship department.
employment,
And entrepreneurship department.
where do you get it?
My lord, in a postal, my lord. My response number 1.
Skill,
My-
employment
yes, ma'am.
and entrepreneurship department,
Earlier, my lord, this was, my lord,
for applicant.
my lord,
Mr.
applicants.
Applicants, next, this is an application under section 5 of the Indian Limitation Act 1963. Praying for condonation of 12 years. 12 years.
Well, we have made the.
Notice is not required.
My lord.
Notice is not required. We'll
Let the
dismiss.
notice go- let the notice go, my lord. Let the notice go.
12 years, 7 months.
Yes, my lord. My lord, my lord.
I have never come across
My lord,
in
my
my
lord,
entire
yes,
career.
Yes, I understand, my lord. I understand.
As a lawyer also.
Yes, my lord, I can.
12 months, 12 years is,
My lord,
it's a height, yeah?
my lord, this file was moving from this to that to this to that, my lord.
12 years, seven,
Yes, yes.
7 months, 20 days, 20 days in filing the connected review application. Review petition. Against the
My lord,
judgment and order.
judgment and order, my lordship will find at page number 44.
Judgment and order dated
Dated 8/1/2013.
8/1.
2013. Passed in
8/1/2013. Passed in WPC
number 6011.
6011 of 1999. 1999. Issue notice referable for which Mr. The land council by the applicant to take steps for service of notice upon respondent, sole opposite party. Public writ petitioner.
Leave the person.
Chances are bleak.
Yes, madam. But this file was moving from this to that, my lord. Ultimately, the chief petitioner give his approval, my lord.
Yes, IA. For what? Nobody appears. No one appears for the petition. I will call Mr. B. Chaudhary, London Standing Counsel. SSA is present, list after 3 weeks.
59, 58, 58.
Milord, we were supposed to file the amended cost title.
Ah,
We have filed the cost title and we have taken steps also.
yeah, file.
My lord, we have filed and we have taken steps.
Then
Then, Milord, my another prayer, Milord.
the
Along
has
with this-
filed a fresh memo, emergency for the necessary correction have been endorsed in it. Well, so the notice will issue, notice will go.
Notice has already been issued, Milord, to
Okay,
the
you have
amended.
taken steps.
Yes, Milord.
It doesn't say so.
But it may not be reflected, Milord. We have taken on.
It is submitted by Mr. S. Chamwa, learned counsel for the petitioner. That the
A.
steps,
Chamwa.
steps, huh?
H. Chamwa.
S. Chamwa, I said, what I said?
H.
A. S. Chamwa, learned counsel for the petitioner. That the steps has already been taken in respect of, for notice upon respondent. No, all.
All respondents. Milord. We have taken steps on against all respondents. We have taken the
Records,
steps
huh?
for the second time.
When?
The latest is the second time. After
doesn't-
correction of the cost title.
It doesn't reflect. Please, however, there's no office noting in that regard. Please accordingly registry to verify. And you verify and do the needful. List after,
My lord,
list after 4 weeks.
my lord, along with these matters, my lord, there are two connected other contempt matters, my lord. If I may please
List-
for lordship, my lord.
List this matter along with contempt
Contempt 19/2026 and 21/2026.
20
One.
and 20.
This
20
is, today is listed 20/2026. The other two is 19/26 and 21/26. Maybe listed together. Yes. Obliged.
List the matter along with contempt case number 19 of 2026 and 21, 2026.
Item 59.
My lord, I have filed this IA in pursuance to order.
Huh?
I have filed this IA in pursuance to order dated 15/5/25. Allowing me to file application for amendment, my lord.
Application for?
Amendment, only the, not amendment actually, my lord. The cost title, I am challenging the order of appointment of respondent number 7, as well as the order of posting. And consequent prayers in the prayer portion, my lord. So it is only when the respondent number 7 has filed the affidavit, I have come to know the appointment, his appointment order and the order of.
So,
So, my lord, I am challenging those, my lord.
by way of amendment.
In the matter, in the.
By way of amendment.
Yes.
Let him file an amendment read petition.
Okay. Heard Mr. Learned counsel for the petitioner. Decision, and also had Mr. P.K. Bora, learned standing counsel for
Number 1 to 5.
elementary education department for all. What about this?
6 Malar headmaster,
Six,
Malar
seven.
notice has to go, Mal.
Then we'll issue notice.
Earlier.
They may have some objection also.
My lord, earlier.
No, then we'll issue notice because private respondent is there. You are challenging the appointment.
Private respondent has received notice, my lord. His name is there. It's been
No,
replaced.
private respondent, another
Not in the-
headmaster
in
is
this
also there.
amended
I have
petition.
given him copy, my lord.
Huh?
I have given him copy, my lord.
So bring him then, unless he,
Just the council was here, my lord.
he ran away.
But he is there participating. He filed a affidavit also, my lord, in this.
Affidavit, I mean, the objecting this application.
The original.
Their earlier read petition.
Original
Now he want to-
affidavit in opposition. From their affidavit on opposition, I have come to know about her appointment order and order of posting.
Say, why don't you withdraw and file a fresh petition?
Only again.
Why you are making it clumsy, unnecessary?
Again, notice will have to wait for the notice and all this things.
You served that the lawyer, your friend. Please, just because notice has to go, it may be delayed. It's not a question of what we will do. Because tomorrow he may come and say that because it doesn't indicate anything whether a notice has been already served. It's the first time, listed for the first time.
Yes, IA is already there, man. I have served him copy. He appeared.
But then it doesn't reflect anything. Tomorrow he may say so, right? Unless notice is issued, he just cannot accept it. Is it listed for the first time? See, I have no difficulty in allowing this application. But tomorrow your colleague may raise objection because it doesn't indicate. Except your submission, record doesn't indicate that whether he's been, notice has been given to him or not.
But in the original petition, he filed affidavit.
I
have given
understand.
him copy, my lord.
Yes.
He
Then
appeared.
he has filed an affidavit
Hmm. Yes,
Right.
filed affidavit.
against. I think, sir, best way out is to, if there's a new orders or the orders which have no, you have no put to challenge, instead of making it clumsy, withdraw this writ petition and file a fresh. Otherwise, for us, no difficulty.
Well, the private respondent is there, my lord.
So they may say record doesn't indicate, or else we'll just issue a notice at this stage.
So I'll let
For
the
your benefit only, I'm saying, I'm just suggesting. What do you say?
let the matter be fixed up day after tomorrow. I'll call him and make him appear. Already I have the copy.
Then we'll issue notice. Return it by 2 weeks.
Yes.
Huh?
He has received notice, my lord.
And Mr.
DK Bakshi.
This is Bakshi, let me counsel for the petitioner. This is an application praying for amendment of the writ petition
The objection.
being WPC 633 of 2024. Next paragraph. Issue notice returnable by 10 days. Returnable within 10 days.
I'll serve
As Mr.
personally, my lord, to the
Uh,
council.
P.K. Bora, learned Standing Council Secondary Education, enters, Elementary Education Department, enters and accept notice on way of respondent, opposite party. Number 1, 2,
1
3,
to 5.
4 and 5, no formal notice need be served. However, extra copies be furnished. Extra copy furnished, to Mr. Bora. Petitioners to take steps. Then council will just take steps for service of notice upon respondent 6 and 7. Vedasti,
Yes,
as
my
well
lord,
as you-
personally, I'll serve the 2-7.
list the matter after
My lord,
10
date may be
days.
fixed, my lord.
10 days.
I am without salary, my lord. Date may be fixed. Date may be
Give that.
fixed.
We have granted you to take steps by Dusty also.
Yes.
If it doesn't appear, you have to file
Yes,
that.
affidavit. Huh?
Obliged.
Over.